an appeal in the matter of YC and the Home Department.
Yes, okay.
May it please the court, I represent the appellant in this matter with my learned friend Smith, Mr. Blundell, and Ms. Massoud represents the Secretary of State. We are in receipt of the court's email about...
Yeah, I'm sorry it didn't come before, but inevitably just thinking around it,
yes.
it was a case in which my lady and I were both involved, and we just thought it might be relevant. Whether it is obviously for you to assess it by way of submissions.
Yes, I may ask for a little time to...
Yes, of course.
Read through it. But yeah, yes, I think I've grasped the thrust of it. And I can perhaps deal with it as I go along. May I also just briefly address the point put to us yesterday by the court by email? Now, the parties agree, as I understand it, that the Secretary of State did have the power to grant Mr. YC indefinitely, albeit outside the rules. So this isn't one of those cases where the grant was invalid, as it were, ab initio, for want of power. I'm not sure how much further my learned friends are prepared to go in conceding, and obviously I will respond to any points that they might want to raise as to the lawfulness of the original decision. What I would just say, as it were, is that the court will recall that the Secretary of State did, at the permission stage,
raise it, and it didn't feature in the detailed grounds. No, that is why we raised it with the parties, as it were.
Yes, they raised it and they chose not to pursue it, and we respectfully say rightly so. And of course, the tribunal doesn't decide it on that basis, on the basis of any issue of the lawfulness of the original ILR decision. And of course, we have no respondent's notice, nothing in my learned friend's skeleton on this point, and it would be very late. We respectfully say to raise any such points now, were the Secretary of State inclined to do so. And I'm bound to say any arguments of that sort would appear challenging in my respectful submission in light of what's said in Vassar, the decision that the court drew our attention to, which I think is footnoted in our skeleton, and also Majera in the Supreme Court. But as I said, at this point I'm content to see how my learned friends put this point, if we do, and to come back, if I may, in reply. So moving on to my skeleton, or our skeleton, if I may, the question we say in this case is whether the Secretary has an implied or incidental power not set out in the statutes to withdraw a valid grant of ILR on the grounds that it was made in error, and obviously we should have power to do so in this case. And we say there is no such power, and we've identified four reasons, somewhat interlinked reasons. They're not intended to be separate grounds of appeal. There are four reasons in support of a single ground of appeal, as set out in our amended grounds. So, in summary, first of all, the power purportedly being exercised.
Sorry, the power
purportedly being exercised. Sorry, by the Secretary of State amounts in substance to revocation of ILR in circumstances where the Secretary of State accepts she had no power to revoke ILR. She says she's
there's an express power in section 76.
Indeed, and my learned friends, as I understand it, are saying, well, the power is not the same power as in section 76. We say it's in substance, like an identical power, and one has to look at the substance. Secondly, we point to the fact that Parliament has never legislated to create a power to take away ILR on the basis of a unilateral mistake. And we say the obvious conclusion from that is that Parliament, despite being aware that this could be an issue in some cases, my learned friends say in a very limited number of cases, did not intend such a power to exist. Thirdly, we say Parliament has never legislated to create a power to take away leave retroactively or retrospectively. Now, that is not disputed as a matter of law. So I hope I can deal with that one quite shortly. There is a dispute about whether the Secretary of State's decision in this case did have retroactive effect, or was intended to have retroactive effect, and I'll address that shortly. It's unfortunately not a dispute which is resolved very clearly by the tribunal, although we say the better reading of its judgment is that it did think that it had retroactive effect. As I say, I'll return to that shortly. And then fourthly, the power identified by the tribunal is not in fact an incidental power. It doesn't meet the definition of an incidental power in cases such as New London College. It's a substantive power which could only be created by Parliament. And I would stress, if I may, by way of opening, that the Secretary of State's arguments to the contrary are novel ones. They do not appear, as far as we're aware, to have been advanced to any court at any time since the 1971 Act in force. And that includes in cases where it would have been an answer for the Secretary of State to say, well, I have the power, you may have been granted ILO, but I haven't the power to take it away. We'll come on to that shortly. And indeed, there are instances of the courts accepting and or the Secretary of State conceding that no power exists of the sort that she now contends for. So the Secretary of State needs to persuade you of the existence of an incidental power which has remained unrecognised for more than 50 years. There are numerous changes of legislation, countless changes in immigration rules, through a number of discussions of the implications of the grant of ILR in this court and in other courts. And all of that is in a context where if the Secretary is dissatisfied with the destination to which our submissions would lead, it is open to her, or has been open to her, to invite Parliament to amend.
Just before, thank you very much. And just before you do that, and at some stage, it would be very helpful if you could address the powers of the Secretary of State to withdraw decisions. I mean, at the moment, about 30% of Home Secretary decisions made adverse to appellants are withdrawn in the first tier Tribunal Immigration and Asylum Chamber.
Yes.
And the Chamber would be overwhelmed if there wasn't that power. So perhaps you can work out why they have that power
As with the
if she doesn't have this power.
As with the judicial review courts, of course.
Yeah.
I mean, I think the short answer to that we would say is there is a difference between withdrawing a decision which is adverse to somebody as opposed to a decision which is favourable to somebody, and that if both sides in a dispute, as it were, agree that the decision ought to be withdrawn, then there's nothing to prevent her doing so. And that's a pragmatic, as my lord has said, solution to what would otherwise be a difficult problem for the courts. The courts would have to rule on cases where both sides agree that the decision is wrong or unsupportable.
Yeah.
But it doesn't follow from the undoubted power to withdraw a decision that she has the power to grant it, to withdraw a favourable decision, because in part of the effect on legal certainty and the certainty of the individual's status.
Some refusal letters do have the effect of affecting status. So if I refuse you asylum, you go from a sort of difficult regime to a harsh regime. And then if I withdraw that, then so I'm not sure. Anyway, you address it as and when you want, but I'd be very grateful for an analysis of where the powers to withdraw decisions come from, rather than just an off-the-head response, as it were.
I'm grateful. I will seek to deal with that. May I then turn to the facts, and I'm looking at paragraph 3 of our skeleton. So Mr. YC, as the court will have seen, is a citizen of China. He comes to the UK in around 2000. He claimed asylum sometime later in March 2019. He was claiming, and the Secretary of State accepted this, difficulties with loan sharks and to have been a victim of trafficking. In December 21, he's diagnosed with cancer. I won't take the court to that, but if
we've read the medical notes, yeah.
Yes. So he's then informed on the 13th of November 2023 that his asylum claim has been refused. As I say, the Home Office accepts that he's a victim of trafficking and that he is, as they put it, of adverse interest to a loan shark. However, they think that he can either be protected by the Chinese authorities or relocate internally. And the decision letter, as the court will have seen, at page 239 of the court bundle, Perhaps we could just go there because I think we can look at the wording of the various decisions made. So page 239 is the original decision, 13th of November, and it tells him that he has been granted settlement, indefinite permission to stay, ILR. As I say, it's not in dispute, but that's a valid grant of ILR. Notwithstanding it wasn't intentional, as the Secretary of State has said. So, just pausing there, undoubtedly he has had something of a windfall. And the question, of course, is then whether he's entitled to benefit from it and to continue to do so. And as I say, the cases down the years, which we will come on to, say that he is, as long as he hasn't used deception. And there's no suggestion that he has. And as I say, for good reason, because the contrary position would have caused Mr. YC great uncertainty, not only him, but other people who had to rely on his grant of leave. Employers, landlords, family members, if he had any, for example. However, following correspondence about the appellant's biometric residence permit, I'm at paragraph 9 of our skeleton, page 226 of the bundle, the Secretary of State sends an email saying this has been an error. As I say, there is a dispute about what the Secretary of State intended to achieve with this email and accompanying letter, and perhaps more importantly, a dispute as to what she did achieve.
So a dispute, a factual dispute.
Well, a dispute as to what the effect of the second letter was, particularly as to whether it was retroactive or not.
Right.
So the Secretary of State says to the solicitors, thank you for alerting us to this error. I have attached the correct decision letter stating your client's permission to stay until 12th of May.
That's page 270, is that the one?
226, I'm sorry.
Ah.
Apologise. So the clear implication of that is saying that this is the correct decision letter, which we're now sending. The clear implication is the previous decision letter is incorrect. And of course, 12th of May 26 is 30 months, 2.5 years, from the 13th of November 2023, which was the date of the original decision. And 30 months would be consistent with the period of time people would normally get on human rights grounds. The attached letter, to which reference is made, is at page 229.
What's really puzzling about the quote-unquote correct letter is that it predates the letter that was sent to your client.
It's peculiar. We've had no explanation at all from the Secretary of State.
There doesn't seem to have been any witness statement before the upper tribunal.
No.
And I mean, years ago when I used to do these cases, there were things called GSID notes, which would record what had been going on, and don't seem to be in any of those either.
No, nothing seems to have been produced, no. So yes, the backdating we say is significant. The fact that it's backdated to a different date is still more puzzling.
Yeah.
But the fact that it's backdated at all, we say is significant. Notably, it is clearly intended to be a complete replacement for the original letter, because it tells Mr. YC that his asylum claim has been refused, something he already knows. Mentions his right of appeal, again, something he's already been informed of. And then it confirms in the penultimate paragraph on 229 that he's been granted permission to stay until the 12th of May 26. Then at page 232, he again gets the reasons why he's been refused asylum. As far as we can see, those are substantially identical, save for some formatting changes to the original letter. And I'll come on shortly to what the Secretary of State and the Tribunal said about that letter, and also what the Secretary of State now says was the effect of that letter. But just pausing there for a moment, we say it's very clear that letter was intended to, and did, withdraw the grant of ILR, ought to withdraw the grant of ILR, with retroactive effect, so that the appellant had never had ILR. so that he only ever had limited leave. That's particularly clear from the backdating. If it's not the intention or the effect, as I say, the effect is more important than the intention. But if it's not either the intention or the effect, that the ILR is replaced from the point where it was originally granted by the grant of 30 months leave, why is it backdated? Obviously, I say obviously, but the appellant can't have, I don't think this is controversial, the appellant can't have both leave which has an end date of May 26th, and also at the same time leave which doesn't have an end date, which is what ILR would amount to. I think it's not controversial that you can't have had two contradictory forms of leave at the same time. And the Secretary of State, as I say, as my lady has flagged up, has never explained the backdating of the letter, or how it's consistent with the position she now advances, which is that Mr. YC's ILR was taken away only with prospective effect. A letter, we would suggest, revoking ILR with solely prospective effect wouldn't have been backdated. It would have been dated the 22nd of December, i.e. the date on which it was served. And then there would have been no ambiguity. Alternatively, if the letter, despite being backdated to an earlier date, is not intended to have effect from the date which appears on its face, if it's only intended to have effect from a later date, one would expect it to say so. Otherwise, it's very least unclear when it's supposed to take effect. Again, as I say, it's also not obvious why, if the backdated letter was simply informing the appellant of a change in his status going forwards, rather than to entirely replace the original decision letter, it's necessary to inform him again that his asylum claim has been refused and that he can appeal. He knows that. He's been told that. Why is it necessary to send him again the reasons why his asylum claim has been refused? Again, something he's already been told about. Unless, we say, the intention is to make a fresh decision on his asylum and human rights claims, which triggers a right of appeal and which therefore entirely replaces and supplants the original decision, such that the original decision has no effect. So we say, as it stands, this second decision letter, that's the decision obviously under challenge, is clearly intended to replace the original decision ab initio, so that it has the effect that ILR is never granted. And if it isn't intended to do so, we nevertheless say it clearly does have that effect, regardless of what the Secretary of State intended. It does have that effect on its face, obviously leaving aside for the moment whether it's lawful to have done so.
Does the letter take effect from the date, from its date, or from the date when it's served on the appellant?
Date of service would be normal, but these letters are sent usually by email, and if I'm not turning my back on them, I think this was sent by email. I'm told it was sent by email, so it wouldn't make a difference in this case.
Well, except that it wasn't served on the 8th of November by email.
Oh, I see. No, it wasn't. No.
No. So it might not have taken effect from the 8th of November.
Oh, I beg your pardon.
Sorry, it's my fault for not asking a clear question.
No, my fault for not understanding it. But well, that is an open question. That is one of the mysteries of this case. But we say if one looks at the wording of this letter, the date on this letter, the wording of the current email where it talks about this being the correct decision letter, all of those things point to an intention to this second letter taking effect with retroactive effect from the date, well, either from the date of, well, I suppose from the date of the 8th of November. So the as it were, pre-backdated, the backdated second letter.
But the sequence of events is that the letter dated the 13th was served first by email, and then
Yes.
the letter dated the 8th was served later.
Yes, on the 22nd of December. So, as I say, the Secretary of State's position on this hasn't been entirely clear. Her position has somewhat shifted over time. Her initial position in pre-action correspondence, which I think we don't need to go to, is consistent with the backdating having had the effect that the appellant never had ILR, only had 30 months limited leave. Because, of course, at the pre-action stage, the Secretary of State's position is that he he's never been granted ILR. Obviously, she then retreated from that position. And the key point then, of course, is what the tribunal considered to be the effect of the decision letter, which unfortunately isn't unambiguous. But perhaps I'll come on to what the tribunal decides after I've gone through the statutory and case law background, if I may. So, may I ask the court to turn to paragraph 17 of my skeleton? And it will be a familiar concept to the court that the basis of UK immigration law remains the 1971 Immigration Act, described, I think, by Lord Sumption in New London Court as not having stood the test of time very well, but nevertheless it remains the fundamental basis. Requires those who aren't British citizens to have permission to enter or remain. Permission is granted by the Secretary of State or by immigration officers. Paragraph 18, section 3 provides that leave to enter or remain may be granted either for a limited or indefinite period. Perhaps I could just ask the court to turn up the authorities bundle, as I think we're going to need to look at the statutory provisions. So in hard copy bundles, it's bundle 1, tab 1, page 21.
Section 3.
Section 3 of the
So
immigration
the electronic copy marries with the hard copy.
a bit big, my lord.
I said the electronic copy page numbering marries with the hard copy.
I do hope so, yes.
Yeah. It's a bit of a rarity.
Yes, section 3(1)(b) provides leave to be granted for either a limited or indefinite period. Indefinite leave is leave which is not limited as to duration. We get that from section 33. I don't think we need to go there, it's not controversial. And then 3(1)(c), limited leave may be granted subject to conditions, various conditions, employment, studies, access to public funds, but no power to attach conditions to ILR. And then a couple of pages further on, page 23, section 3(3), in the case of limited leave, a person's leave may be varied, whether by restricting, enlarging, or removing the limit on its duration, etc. So the power to vary or amend the duration of somebody's leave under that provision, at least, only applies to limited leave, doesn't apply to ILR. And both of those subsections have been materially unamended since 1971. So from the outset of modern immigration law, we have this clear distinction between limited leave and indefinite leave, and people with indefinite leave having additional advantages and protections people with indefinite leave having additional advantages and protections that limited leave don't. And then just briefly back to page 22, subsection 2, this is the origin, of course, of the immigration rules, requiring the Secretary of State to lay before Parliament statements of the rules or any changes of the rules laid down by him as to the practice to be followed, regulating the entry into and stay in the UK for persons required to have leave, including any rules, line 3 and 4, including any rules as to the period for which leave is to be given and the conditions to be attached in different circumstances. It goes on to say that once laid before Parliament, either House has the opportunity to disapprove it by way of a negative resolution procedure, and I'll come back to the importance of that. Paragraph 21 of my skeleton, I've cited a case called Patan. I don't think what is said here is controversial at all. There are numerous adverse consequences which the court are aware of not having leave to remain. And again, the reason this matters is that certainty is important, and we say the Secretary of State's position in this case leads to a lack of certainty.
Can we, just before you leave section 3, note 3(3), because although that refers to limited leave, it may or may not be significant that it expressly gives a power to vary, whether by restricting, enlarging, or removing.
Yes.
limit. Does ILR have any such provision?
Well, we will come on to that. The Secretary of State essentially had to legislate, Secretary of State Parliament had to legislate specifically, and that's Section 76, which we'll come on to take away ILR. And there's also a discussion of this in my Lady Justice Elisabeth Lang's judgment in C1, which we'll be looking at shortly. But as far as the four corners of that subsection go, it doesn't apply to ILR, and I don't think anybody's suggesting it ever has or could.
No.
So if I could move on to paragraph 25 of my skeleton, please. Section 4.1 of the Immigration Act, which is at page 36 of the same tab, requires, so far as material, that the power under Section 3 to grant leave should be exercised by notice in writing. So this is line 4. By notice in writing given to the person affected. Again, not in dispute, but it's clear from that it's the act of notifying the individual concerned which constitutes the grant of leave. So it's not the position that leave is somehow granted internally within the Home Office and then notified, or not notified, as the case may be, to the individual, which seems to be the Secretary of State's position in pre-action correspondence, not now, as I understand it. And as I've said, in paragraph 25, case of Minton, perhaps we just turn that up, please. It's bundle 1, tab 19, beginning at page 300. I'll need to look at Minton again later, I think. But essentially, for present purposes, the majority in this court accepted the submission that a notice under Section 4 must specify, within its own terms, as it were, the duration of any limited leave, and that the terms of the grant of leave can only be discerned from the notice itself. And importantly, for the point I'm currently making, all three members of the court agree that no distinction exists between the decision to grant leave and the communication of that decision. So Lord Justice Glidewell, top of page 303, he is...
Sorry, top of page?
303.
Thank you.
So he's citing a submission, but it's a submission he agrees with. The notice in writing required by Section 4.1 is not merely evidence of the grant or refusal of leave, but is itself the means by which the function of the immigration officer in granting or refusing leave is exercised. As I say, I'll return to Minton later. As I said, paragraph 26 of our skeleton, the same view is reached by this court in case of Ahmadi. I don't think this is controversial. I don't think it's in the bundle, but as I've quoted there, the notice in writing is not a subsequent step following the exercise of the power. It is the way in which the power is to be exercised. The decision-making process prescribed by Section 4 is not the making of a decision followed by the notification of that decision to the person concerned, but the making of a decision by giving notification of it to the person concerned, and likewise paragraph 27 and more. So in summary, the general position is that a letter granting leave is a grant of leave. It confers the leave. And as we shall see in a moment, there are some exceptions for fraud, there are exceptions for want of power, but obviously those are not an issue in this case. Section 26 of my skeleton, there are various powers to vary, revoke, cancel, curtail leave. In the case of ILR, for someone within the UK, it's different if you're outside the UK, but for someone within the UK, these are principally Section 5 of the Immigration Act relating to deportation, and Section 76 of the 2002 Act, providing the power to take away ILR in certain circumstances, and I'll go to each of those in a moment. There's also powers relating to people outside the UK, which arise in Section 3B of the 71 Act, and related secondary legislation. Again, we'll come on to those in a second. But before we do that, if I may, as I said at paragraph 29, various words and phrases are used in different places in the legislation and the rules. We say nothing material turns on the use of different terms such as vary, curtail, revoke, etc., invalidate. So although the Secretary of State has been at pains to say that what she did in this case was to withdraw or replace, those are the terms she's used, withdraw or replace the appellant's ILR, which she says in some ways is in some way different to revoking it. We say the terminology doesn't matter. What we need to look at is what she did and whether what she did was in substance the same as a revoking, which is the phrase used in section 76. And this, I think, was uncontroversial in the case of C1. Perhaps I could just turn that up. It's bundle 2 in the hard copies, tab 39, page 755. Start 755. And so this is a case where the contents are slightly different. So this is the Secretary of State invoking the power, which she undoubtedly does have, to take away ILR for a person who's outside the UK. And if we turn to page 773, please. This is setting out a submission, of course, on the part of the Secretary of State. But it's a submission which, on my reading at least, is approved by the court, and in any event we say it's correct. This is submission of Mr. Tam, Queen's Counsel. He says, nothing turns on the use of different verbs to refer to the same underlying concept. That usage recurs in the legislation. Section 5.1 of the 1971 Act used the word invalidate. Section 76, revocation. Section 7 of the 1993 Act, curtail, a word which is used in several different provisions of the rules. The right question to ask is what the Secretary of State has done. When the Secretary of State cancelled C1's leave, she reduced its length to nothing. That's a variation. The submitted Section 76 was enacted to fill a particular gap, which would have existed if the Secretary of State's, even if the Secretary of State's submissions are correct, applies to in-country cases, not those who are outside the UK. Without it, the Secretary of State could not bring ILR to an end if its holder is in the UK, unless she made a deportation order. So that is the Secretary of State accepting, in that case, that she has no power to do what she says in this case she does have. Namely, bring somebody's ILR to an end while they're in the UK, other than via either Section 76 or by way of deportation. And indeed, he goes so far as to say the reason for Section 76 being introduced is the lack of power. There was no other power. That's why Parliament needed to legislate. And that is accepted by the court. And perhaps I could turn to page 777, please. Paragraph 68, my lady confirms Parliament did not confer a power to vary or restrict leave under Section 33A, which we just looked at. And then 71, perhaps I could just ask the court to read 71, because it's on the long side. continue. And then finally on this case, page 782, please, paragraph 95. The judge below, final potential reason for rejection of what he describes as Mr. Tam's submission that variation, cancellation and revocation are effectively interchangeable. That's not how I understand Mr. Tam's submission. Mr. Tam's point is rather that variation means change and that it can include, but is not coterminous with cancellation and revocation, which are self-evidently narrower concepts. I accept Mr. Tam's explanation for the enactment of section 76 of the 2002 Act. So, as I say, the point we make on Mr. Tam, which we respect as correct and on my understanding is accepted, is not that all these expressions mean exactly the same thing, but that what really matters is the substance of what the secretary has done. And the point, of course, about, as I say, the point about section 76, which is accepted by the court, is that it is needed because there was no other power to take away ILR outside the deportation context. So, paragraph 31 of our skeleton, perhaps I could ask the court to turn back to section 5 of the Immigration Act, bundle 1, tab 1, page 38.
In the authorities bundle.
Sorry, yes, authorities bundle tab 1, page
Yeah.
38. So this concerns persons liable to deportation under the 71 Act, and the last two lines of 5.1 are that a deportation order against a person shall invalidate any leave to enter or remain in the UK given him before the order is made or while it's in force. And in the case of Fitzroy George, which is bundle 2, tab 31, beginning at 523, the Supreme Court said at 529, paragraph 13, that up until section 76 was enacted, indefinite leave to remain could not be removed except by deportation within the operation of section 5.1. So prior to 2002, that's the only power to take away ILR, making deportation order. So there's not a hint of a suggestion in that case, in the George case, by either the Supreme Court or by the Secretary of State, that there's some other power outside the four corners of the legislation. I won't dwell on what I've said at page paragraph 32. Perhaps I'll just go to paragraph 33. So the next relevant provision is section 3B of the 1971 Act. This is tab 1, page 30 of the authorities bundle. And this provides 3B1, the Secretary of State with discretion to make further provision with respect to giving, refusing or varying of leave to remain in the UK. And section 3B3, an order under this section may contain incidental, supplemental, consequential and transitional provisions as the Secretary of State considers appropriate. And an order is made under section 3B, which is the Immigration Leave to Enter and Remain Order 2000. That's in the authorities bundle, bundle 1, tab 12, beginning at 164. And the relevant, first of all, by general observation, by way of general observation on this piece of secondary legislation, it contains no power which is relevant to this case, although section 3B seems to be broadly drafted. The order made under section 3B contains no power relevant to this case. What it does have is a power to take away ILR while the person is abroad. So that's page 192, Article 13. So Article 13.2 leaving aside A, where a person has leave to remain which is in force and which was B, given by an immigration officer or a Secretary of State for a period exceeding 6 months, such leave shall not lapse on going to a country or territory outside the common travel area. That's obviously the UK and Ireland, the Channel Islands. And then over the page, subsection 6, where the holder of leave which remains in force under this article is outside the UK, the Secretary of State may vary that leave, including any conditions to which it's subject in such form and manner as permitted by this order. And Article 13.7, where a person's outside the UK and has leave which is enforced by virtue of this article, that leave may be cancelled by an immigration officer or the Secretary of State. So a specific provision allowing for leave, which implicitly includes ILR, it doesn't say it's only limited leave, to be cancelled while a person is outside the UK. But nothing equivalently permitting the cancellation or variation of leave for somebody who's in the UK. And as I say, that's the provision which was under discussion in C1, the case we just looked at. Then the third piece of legislation I'd like to look at is Section 76. There's a certain history behind Section 76, which starts with Section 10.1 of the Immigration and Asylum Act 1999. Now, as originally enacted, and this is Bundle 1, Tab 4. Yeah, Bundle 1, Tab 4, page 76. As originally enacted, Section 10.1 provided that a person who wasn't a British citizen could be removed from the UK if they haven't observed a condition attached to their leave, or has obtained leave to remain by deception, would appear to include somebody who had obtained ILR by deception. And then by 10.8, again as originally enacted, directions for the removal of a person given under this section invalidate any leave to enter or remain, again obviously including ILR, in the UK given to him before the directions are given or while they are in force. So Parliament there legislating for ILR to be taken away if deception has been used. Again, got an opportunity there to say the person could also be removed, could also have their ILR taken away if it's been granted by the state, an opportunity not taken by Parliament. And that provision in 10.8 has now been superseded by Section 76. And the current version of Section 76 is at Bundle 1, Tab 8, page 148, please. So this is Section 76 as currently enacted. It has gone through one or two changes, but nothing, I think, material for today's purposes. So that provides the Secretary of State may revoke a person's indefinite leave to enter or remain if the person is liable to deportation but cannot be deported for legal reasons. That's 1. 2, their leave was obtained by deception. Or 3, if they have ceased to be a refugee, or somebody whom they are a dependent has ceased to be a refugee. And the court will recall the acceptance in C1 that this was enacted because there's no other power to allow ILR to enact, other than in the context of deportation. Now, there's no dispute, as I understand it, that Section 76 does not operate retroactively, only with an effect in the future. So it doesn't operate so as to deprive the individual of the status they had in the past. And once again, what we see as absent from that is a power to revoke ILR by mistake. So again, Parliament could have chosen to grant such power, but it didn't. Nor do the immigration rules, paragraph 39 of our skeleton, contain any powers to cancel or curtail leave on the basis of mistake. I'll return to what the rules say shortly, but I think it's uncontroversial at this point to say there's nothing in them which suggests the existence of a discretion to do so on the basis of mistake. And as we've said at paragraph 40, it is a long-standing principle, in fact, that a grant of ILR is valid and must be honoured, even if it's made accidentally, as long as there was power to make the grant, as we all accept there was in this case, and as long as there's been no deception. And despite this series of cases, which I'm going to take you to now, dating back to 1978, we say it's significant that Parliament has never legislated, never stepped in to provide a power to withdraw an accidental grant, nor actually has any attempt been made before this case to assert that there is such power, as it were, lurking in the undergrowth around the 1971 Act. So the first case we need to look at, if I may, is RAM, that's bundle 1, tab 17, page 279, sorry. 117, 279. And if we could just turn to page 281, please. This is a habeas corpus case, just for context. And we can see just above D, on page 281, the claimant had arrived at Heathrow. He presents his passport. It's stamped by the immigration officer with leave to enter and remain for an indefinite period. That's just below D. By F, it's accepted that that is a mistake. But again, no suggestion of deception on Mr. Ram's part. And by G, we can see that he then leaves the UK on a number of occasions. And on each occasion on his return, he's granted ILR again. Again, no claim of deception on any of those occasions. Then page 282, by B, you can see he's then detained by the Secretary of State under immigration power. And 283 by B, we can see that the Secretary of State's case is that his detention is justified on the basis that he's entered unlawfully, that he's an illegal entrant. And that's just above H, in fact. And as the Secretary of State cites authority for that submission, but the court distinguishes those cases on the basis that they were cases, those other cases, were ones where deception had been used. And we can see that from page 285. So just above F, on page 285, the paragraph beginning, in my opinion, the contention that an entrant can only be a lawful entrant if he comes within one of the categories in HC 79, that's the immigration rules, of course, and if further, he's only allowed in for the usual period appropriate to that type of entrant. But if by mistake the immigration office gives leave to enter otherwise than within those categories, within the categories and the rules, or for that period, for that usual period, then the immigration office had no authority to do so. That contention, where an entrant is prima facie lawful and his entry is not induced by any fraud or dishonesty, goes too far, and is one for which my part I'm not prepared to accept. Then the last two lines of 285, this is not a case in which, in my view, looking at the evidence taken as a whole, the Secretary of State over the page has any reasonable grounds for coming to the conclusion that this applicant is here illegally. He's here pursuant to a leave granted stamped in his passport, to the grant of which he contributed in no way by any fraud dishonesty on his part. And so it follows, in short, that the claimant is lawfully in the UK pursuant to that grant of ILR, and therefore his detention has been and was unlawful. Again, if there was a power, as identified by the tribunal in this case and contended for by the Secretary of State, to withdraw his ILR on the basis that it had been issued by mistake, obviously the Secretary of State could have done so in Mr. Round's case at any point, rendering him either unlawfully or at least prospectively unlawfully present. But nobody suggested that was a possible answer. And that precedent established by Ram some 5 decades ago has been confirmed consistently since then. The next case I'd like to take the court to, if I may, is Richachi, decision of Mr. Justice Davis, which is bundle 1. Sorry, I haven't made a note. Oh, it's 24. Sorry, bundle 1, tab 24, page 380. Now, Richachi is primarily concerned with the consequences of change of policy by the Secretary of State from a position where, as in the past, everybody recognised as a refugee got ILR immediately, to a position where they got 5 years limited leave before they could subsequently apply for ILR. And there are various arguments advanced with relatively little success, but a particular point for our purposes arises in the case of one of the claimants called Mr. Kalobo. And we see this from page 401, paragraph 80. And we can see Lord Justice Davis records that it was the intention of the Secretary of State to grant him 5 years leave to enter or remain. In the event, following page 402, paragraph 82, what he had got was a status document endorsed with, amongst other things, line 4 of paragraph 82, the phrases settlement and indefinite leave to enter. Again, no suggestion of any fault on Mr. Kalobo's part. And then page 403, paragraph 93, sorry, 92, I beg your pardon, the marked passage, paragraph 92. Mr. Justice Davis says, as he then was, says, my task is to interpret this particular status document, so it's the court's task to interpret.
Sorry, which paragraph was that?
Sorry, 92 on page 403.
Thank you.
My task is to interpret this particular status document, as I say, the court's task to interpret it objectively, obviously. And then he says at line 2, if its wording has a particular meaning and effect, then absent deception, that is the meaning and effect which must be given to it, even though some mistake may have occurred. And he cites Ram, which we just looked at in another case. And then paragraph 93, he concludes on an objective reading of the status document which had been issued to Mr. Kalobo that he had in fact been granted ILR. That's line 3. Again, there's no suggestion that the Secretary of State could have avoided the difficulty by withdrawing the ILR. To the contrary, page 404, paragraph 97, 97.3, at the bottom of page 404, Mr. Justice Davis notes that his attention wasn't drawn to any statutory power entitling the Secretary of State to revoke or alter a status document on grounds of unilateral mistake, nor, it appears, was there any suggestion made that there might be some extra statutory power. And we say that's significant. It would have been a complete answer to Mr. Kalobo's case, or this aspect of Mr. Kalobo's case anyway, to say, well, it doesn't matter what he's been told. It doesn't matter what his stamp says, because we can take away his ILR. And that is what we're going to do. That would have been a complete answer to his case, but nobody suggests that, and Mr. Justice Davis is at pains to make that very point. Now there are cases, as I've said at paragraph 45 of our skeleton, that where a grant is not treated as valid because there was no power in law to make the grant. But as I say, that's not this case. There's no dispute that there was power. Then paragraph. I'm so sorry. Could I have some water, please? I can't quite reach that. I can't quite reach that. Sorry, thanks so much. So I'm not going to dwell, I think, at great length on what I said at paragraph 46 on the question of whether variation may be retrospective or retroactive. Because as I say, my understanding is it's not controversial that the Secretary of State could not cancel the retroactive. That's been accepted to be the position for at least 20 years, around about 20 years, since NM's and Barbary was decided in the Tribunal. Obviously, the Secretary of State says that isn't what she did. We say it is what she did, whether she intended to or not. But either way, it's in dispute that couldn't have been lawful, as I understand it. So I'll pass over what I've said there. And perhaps I could just turn to paragraph 52, which is where 52 on the skeleton, which is where the Tribunal had to say about all these disputes. So by the time he comes to apply for judicial review, the appellant's understanding is that his ILR has been replaced by the grant of limited leave. That's what the Secretary has told him. So the intention and the effect, this is his understanding, is the intention and the effect of the Secretary of State's decision, if it was lawful, was that he had never had ILR. So the fresh decision had retroactive effect and not just prospective effect. As I say, the Secretary of State now says that's not the position. The difficulty is that it's not entirely clear what the Tribunal made of that. And in fairness, with respect to the Tribunal, it was faced with a slightly moving target in terms of what the Secretary of State asserted that she'd done, because her position in pre-action correspondence was different from her position before the actual Tribunal. But if one looks in the main bundle at the Tribunal judgment, and I want to look at page 100, please, of the main bundle. At paragraph 11, the Tribunal characterises the claim as a challenge to the decision of the respondent for him to substitute is the word they use, the letter sent on 22nd of December 2023, dated 8th of November, referring to a grant of limited leave, for the letter sent on 8th of November 23, that should say 13th of November 23, of course, because that was the original letter. So substituting the letter sent on the 22nd of December, dated 8th of November, for the letter sent on 13th of November, which is referred to a grant of ILR. So notice the backdating there. It's no longer in dispute by the time the matter gets before the Tribunal. The Secretary of State's original decision letter, the 13th of November letter, did constitute a grant of ILR. And we would suggest that the language the Tribunal uses of substituting one decision for another most naturally suggests that it did think that the original decision was intended to have had no effect, that the original ILR decision was intended to have no effect. If one substitutes X for Y, then Y is treated as having had no effect, naturally, we say. As I say, the context again is the backdating. Paragraph 12, it then says that the appellant is arguing that the respondent, line 1 of 12, having communicated a decision to grant ILR, has no power to revoke, change, or withdraw or change that decision. And again, we say the most natural reading of change that decision is that the original decision granting ILR is ineffective or is intended to be ineffective. as we've said at paragraph 54 of our skeleton, it's also not in dispute that the Secretary of State couldn't rely on the power to revoke in section 76. That's Court Bundle, page 105, paragraph 35. Instead, it's submitted at paragraph 36.
Oh, sorry, you were going, but what are we looking at now?
I do apologise. I'm in the Tribunal's judgment at page 105 of the main bundle, under the heading Respondent Submissions.
Right.
So 35, it's conceded that the power under section 76 can't be relied upon. Sorry, so, first of all, accepted that the original letter is a grant of ILR. Secondly, accepted that section 76 can't be relied upon. And then 36, the submission is being made that what the respondent sought to do on the 22nd of December 23 was not to revoke the grant of ILR, instead it was the withdrawal and correction of a decision letter, which by inadvertence contained the wrong decision. Not made entirely clear, if I may respectfully say so, what the difference between revoke and withdraw is supposed to be. The submission at 37 is then that there's a power to do that, which is line 1, reasonably incidental to the respondent's powers to grant ILR, contained in the 1971 Act. Reference made to New London College, which we'll come on to shortly. And then paragraph 40, reference made to a number of cases in different contexts where a power to withdraw and correct a mistaken decision has been found to exist. Again, we've addressed those cases in our skeleton, and I'll come on to those if time allows. Still within the Tribunal's judgment, page 108, under the heading Discussion, paragraph 46, the Tribunal doesn't accept that any of the cases relied on is precisely on point. It notes that Ram and Chachi and other cases in the immigration field don't specifically address the existence of a power to revoke a mistaken grant of ILR. Obviously, just interpolating, we accept that's true. Obviously, we say the fact that nobody has ever, including in those cases or any other cases, contended for the existence of this power, tells its own story. But the Tribunal, as we say, so far as it goes, correctly notes that these cases don't determine the point. And then it says at 48, the various cases from other areas of law, so it's a housing case and 2 disciplinary cases, demonstrate that in some circumstances a public authority will have the power to reopen a correct decision based on a fundamental mistake of fact. However, line 4, in our judgment, the question of whether a specific decision can be reopened and corrected will always depend on the factual and legal context. We would respectfully agree with that point. And then 49, the Tribunal doubts that the case before it could be properly described as one of a fundamental mistake of fact, as in the cases cited by the Secretary of State. Rather, on the Secretary of State's case as pleaded, final line of 108 and over the page, I note that the decision maker decided to grant limited leave, but through a clerical act, used a letter template which communicated an unintended grant of ILR.
Did that emerge in submissions, or was that part of the written evidence?
That a letter template had been used.
Wrong letter template.
What's
the source of that?
There's no evidence was produced, and in fairness, it wasn't disputed by the appellant below. But as far as I'm aware, I'll be corrected if I'm wrong, but as far as I'm aware, there wasn't any specific evidence to show that was the case.
But that statement of fact, as it were, is not an issue before us. Is that right?
Is
not an issue before us.
no, it's not. No,
Yeah. I mean, it seems an inference that could be drawn. Not the only one, but an inference.
that was what the Secretary of State pleaded.
Yeah.
That it had been the wrong template used.
Yeah.
And that was never disputed. And I
Okay, thank you.
So the tribunal then goes on to say at page 109, paragraph 52, that the question is whether the respondent can correct an error of the kind described, whereby pure inadvertence the wrong decision is communicated. And it concludes paragraph 54, that the Secretary did have the power to make the correction, and such power is reasonably incidental to the statutory powers to grant or refuse ILR. And then 55, this wasn't, in the tribunal's view, tantamount to revocation, which, as they note, is governed by section 76, which didn't apply. Rather, they say at paragraph 56, the Secretary had the power to correct something in the nature of a slip, which had arisen through inadvertence or carelessness, line 3. And if such power didn't exist, line 5, there could be serious, paragraph 57, I beg your pardon, paragraph 57, line 5, if such power didn't exist, there could be serious consequences for the public interest. For example, in the case where ILR had been inadvertently granted to a person who was disqualified for such a grant by having serious criminal convictions, moreover, would amount to a failure to treat like cases alike. Over the page 110, page 50, paragraph 58, the situations in which such power could be exercised would be rare, line 3, and the tribunal added in this case, the error was discovered quickly and there was no evidence that anything had been done in reliance on the erroneous decision. So what the tribunal doesn't do, unfortunately, at any point, we say, is make explicit whether it's treating the Secretary of State's decision as one which took effect, or was intended to take effect retroactively, or as one which only took effect prospectively. As I say, it does say at paragraph 11, which we looked at on page 100, its understanding is that the Secretary of State purported to substitute the amended backdated letter for the original grant of ILR, and it talks about the decision to grant ILR having been withdrawn. Again, the passage we just looked at. We say that's most naturally read, particularly in the context of the backdated letter and so on, that it did think the Secretary of State's decision took effect retroactively. And it certainly doesn't say the opposite. The tribunal does not say it understood the position that the validity of the original grant was unaffected, or that the later letter simply amended the appellant status going forward. Again, obviously we say that position would be inconsistent with the backdating, but the tribunal, with respect, like the Secretary of State, doesn't squarely address the backdating or its significance, although it was clearly aware of it. And it doesn't dismiss the claim on the basis that the amended decision did take effect only prospectively. And if that had been a complete answer, or even just a partial answer to the case being advanced, then one might expect the tribunal to have said so. Maybe, I don't know, maybe the tribunal didn't consider that it made any difference to the existence of the power, whether it could be exercised prospectively or whether it could be also exercised retroactively. But again, if it understood the Secretary of State to have conceded that it was prospective only, it's perhaps surprising that it doesn't record that concession anywhere. I do accept the point made by my learned friends that at least one point in their pleadings and or skeleton, I forget which, perhaps both, a reference to prospective only was made. But if the tribunal had understood that to be the concession being made, they don't record it. And again, we say that's a bit surprising if they understood that that was an answer or a partial answer to the case. Against that background, may I then move on to the reasons why we say the tribunal was wrong to dismiss this application for JR. starting at paragraph 62, if I may, of our skeleton. Essentially, we say this was revocation by another man in circumstances where the power of revocation could not have been used. And as was said in C1, which we looked at, in such circumstances, the right question is to ask what the Secretary of State has done rather than seek distinctions between different forms of language. As I say, the Secretary of State has been at pains in this case to say that what she did was not revocation. And she has to say that because she accepts that Section 76 doesn't apply, can't apply. But instead, she's used these terms like withdraw or correct or replace the decision. But she hasn't, with respect, offered clear definitions of what those terms mean or how they differ from revocation. And so at its most fundamental, our case is that what the Secretary of State has in substance done is to revoke ILR. She's taken his ILR away. The effect is no different to a Section 76 revocation in circumstances where Section 76 doesn't apply. Indeed, I think it's perhaps worth observing that if the Secretary of State is right to say that the decision took place only prospectively, notwithstanding the backdating of the decision making, then there's even less to distinguish the decision that she made from Section 76 revocation. It seems to be exactly the same. Her case in some ways makes more sense if her decision is intended to take place retroactively. Albeit it then, of course, collides with well, she accepts it can't. Right? So the question then becomes, if the decision in fact made it only a decision with prospective effect, which is pretty much identical to Section 76, indeed exactly identical to Section 76, the question then becomes a much simpler one, which is whether the Secretary of State has power to, whether the Secretary of State power to revoke is limited to the circumstances of Section 76, or whether there's some other power to revoke on grounds of mistake, which Parliament, for whatever reason, chose not to mention in the statute. An additional power which has never been identified by any court before this case, including, as I say, in cases where it would have assisted the Secretary of State to identify such power, and indeed, in some cases, it's been said that there is no such power. So we say, with respect, dressing up what is in reality revocation in the language of withdrawal, or correction, or replacement, whatever word the Secretary of State chooses to use, does not assist the Secretary of State if the substance is the same. And it's perhaps telling, as we've said at paragraph 63, that the Secretary of State didn't initially argue that she'd withdrawn a valid grant of ILR. She didn't seek to draw a distinction between that and revocation. A pre-action correspondence, as I say, is founded on a denial that she'd granted ILR at all in the first place. And it's only once the Secretary of State abandons that contention, unsurprisingly abandons it, that she discovers that she did have the power to withdraw or replace the ILR, retroactively or otherwise. A power which she hadn't previously claimed to have, and indeed in C1 she told this court she did not. So that's our first point. Second point, paragraph 65. Parliament has never legislated for mistakes. And we say the Tribunal's judgment departs from, as I say, decades of case law in which no power has been identified of this sort to withdraw a decision made simply on the basis of Secretary of State's own inadvertence or carelessness, or otherwise to correct an erroneous grant. And the power identified by the Tribunal effectively enables the Secretary of State to sidestep the intention, the clear intention, we say, of Parliament, that it's only in specified, limited circumstances that she should be able to deprive a person of ILR. And as we said at paragraph 68, the novelty of the Secretary of State's argument is illustrated by the fact that neither the immigration rules nor her policy guidance contain any reference any power to withdraw leave of any duration on the basis of a mistake. And as I say, the fact that in Ram, in Rachachi, and other cases over many years, nobody has ever suggested the existence of this power tells its own story. Now, I don't, of course, submit that this kind of thing is happening all the time, but it's not entirely unheard of for the Secretary of State to make mistakes. I think I can respectfully say, as indeed the authorities show. But nobody's ever previously identified how to correct these errors, an error of this sort. And Parliament, as we've said at paragraph 69, Parliament legislated frequently, in great detail, in the field of immigration. We have a comprehensive code of statutory provisions, immigration rules, policies, instructions, guidance. As we've said, second half of paragraph 69, in 30 years, up to 2023, there were at least 13 pieces of legislation, primary legislation, leaving aside the Brexit ones, leaving aside the nationality ones. So just dealing with the core, as it were, immigration functions, at least 13 pieces of primary legislation, countless pieces of secondary legislation, innumerable changes to the immigration rules, often decried by this and other courts for their confusing nature. And we respectfully say where Parliament has legislated so comprehensively, so regularly, cover such a wide variety of eventualities, the courts should be slow to identify residual or incidental powers which are not the statute. So as we've said at 71, the 1971 Act, as originally enacted, didn't provide any power for ILR to be varied, didn't provide for it to be taken away in any circumstances other than where deportation was envisaged, or a deportation order specifically was made. That's George in the Supreme Court. It provided no right of appeal under Section 14. I passed over this just for want of time, but mentioned a little earlier in Ask Ellison. Provided no right of appeal against removal of ILR, implying that it didn't intend any such power to exist, again, other than in deportation cases. And there have been no amendments to the scheme, to the 71 Act itself, or to the general scheme of the 71 Act, to insert such power, save for Section 76, which doesn't apply here. Now, the only piece of secondary legislation which is relevant is the one under discussion in C1, which was the Immigration Leave to Enter and Remain Order 2000, made under Section 3B of the 71 Act, and that provides a power to withdraw ILR to a person if they're outside the UK, not to anyone within the UK for any reason. Also, as we say, paragraph 72, striking that there's never been anything in the immigration rules governing any power to withdraw ILR in any relevant sense. On the contrary, in fact, the rules work on the basis that the opposite is the case. And now accept that the rules can't conclusively dictate the meaning of primary legislation. That would be, to some extent, the tail wagging the dog. But the fact that they work on the fact that the rules work on the basis of a particular understanding of the law is relevant because they are rules approved by Parliament. And that's why the negative resolution procedure, which I referred to in Section 3.2, is important. And that is a point made by the Supreme Court in Alvey, by Lord Dyson. This is Bundle 1 of the authorities, tab 28, page 478. So this is a case which, as the court will recall, is all about the meaning of the immigration rules. These two parallel cases, Munir and Alvey, decided at the same time. And page 478 in the sidelined paragraph 94, Lord Dyson stresses that the rule for purposes of Section 3.2 of the 1971 Act is line 2. Any requirement which a migrant must satisfy as a condition of being given leave to enter or leave to remain, as well as any provisions to the period for which leave is to be given and the conditions to be attached in different circumstances. And therefore, in line 8, any requirement which, if not satisfied by the migrant, will lead to an application for leave to enter or remain being refused, is a rule within the meaning of section 3.2 and therefore requires to be laid before Parliament. And then continues by F. The terms of section 3.2 were an indication that Parliament, last couple of lines of 94, wanted to have a say in the rules which set out the basis on which these immigration applications were to be determined. And then on the following page, page 479, paragraph 98, he makes the point that, of course, if the Secretary of State doesn't accept his definition of a rule, he can seek to amend the statute. And obviously the same option is open to her in this case. And then the other case I just wanted to look at again was George. That's bundle 2, tab 31 of the authorities, page 5 to 8.
528.
528, yeah, thanks. There's Lord Hughes, paragraph 12. The wording of section 5.2 made by of the 71 Act may by itself be capable of bearing the meaning that revocation reverses the legal effect of deportation. I'm sorry, I should pause to say that the question, George, is whether if your deportation order is revoked, you revert to the previous leave that you had. I.e., does your ILR resurrect itself, as it were? If it's been taken away by the making of the deportation order and the deportation order is then revoked, does your ILR sort of spring into life again? And the Supreme Court says no, it doesn't. So that's the context of these remarks. So Lord Hughes says, wording of section 5.2 may itself be capable of bearing the meaning revocation of the deportation order reverses the legal effect of the deportation and thus revives leave to remain. But if that had been the intent, one might have anticipated the statute saying so. What is, however, completely clear is that it's been treated from the outset by relevant persons operating or commenting on the Act as meaning that revocation didn't undo the invalidation of leave to remain, which had been achieved by section 5.1. Body of evidence of this is considerable, includes the following. So 1, draft immigration rules prepared contemporaneously with passage through Parliament of the 1971 Act. By H, he says these were considered by both houses prior to the completion of the Act's legislative progress. Draft rules included paragraph 58, which stated in terms, revocation of the deportation order does not entitle the person concerned to re-enter the UK. It renders him eligible to qualify for admission under the immigration rules. 2, that provision was then repeated at paragraph 66 of the changes in immigration rules in October 1972. 3, in line 3, every subsequent statement of changes in immigration rules has contained the same proposition in identical terms, including the current one. All have been laid before Parliament pursuant to section 3.2 of the negative resolution procedure. By B, point 4, successive editions of MacDonald's Immigration Law and Practice record the same proposition without question. If the wording were incapable of contrary reading, an error in its interpretation of the rules, however long perpetrated, wouldn't reverse its correct construction, but this wording isn't clear. Successive assumptions in the rules about its meaning are very relevant when one comes to consider Mr. Nafler's second submission on behalf of the claimant, and in particular the terms of section 76, which is the section which persuaded the majority of the Court of Appeal that he was right. So the Supreme Court, in short, regarded it as relevant to the correct meaning of the legislation that the rules had long proceeded on the basis of a particular interpretation of section 5 of the 1971 Act, namely that ILR does not automatically revive on the revocation of the deportation order. And the point being made, of course, is that Parliament has never corrected that assumption, including when the rules were periodically laid before it. And with that in mind, if we then look at the rules which were in place at the date of the
I think
decision.
it's important to
Sorry.
recognise that he also made the point that the language was ambiguous, and if the language had not been ambiguous, none of this material would have been relevant to its
Yes.
construction.
Yes, indeed. And well, we would say all the more so when
Yeah.
there is no statutory provision at all.
No, quite.
So looking at the rules in place at the date of the decisions in this case, bundle 1 of the authorities please, tab 13, page 206. That's where they begin, or the relevant section begins. The passage I want to look at is page 215. So as I say, these are the immigration rules in place at the date of the decisions in this case. And at 215 we have part 9 headed grounds for refusal. And in the 5th paragraph below that heading, we have the Immigration Act 1971, section 76 of the 2002 Act, revocation of indefinite leave. The Immigration Leave to Enter and Remain Order 2000, that was the C1 order. Schedule 2 of the Immigration Act 1971, repeated for some reason, set out the powers to cancel entry clearance or permission, i.e. leave to remain. These rules set out how those powers are to be exercised. So there's nothing there to suggest that there is any other power outside the expressed statutory provisions, which entitles the Secretary of State to take away ILR. Nothing in Part 9, which refers to any power to cancel ILR, or indeed any other form of leave by reason of simple mistake, leaving aside the section. And as my learned friends point out in their skeleton, since the decisions were made in this case, the rules have been redrafted, and what was Part 9 has been replaced by a section called Part Suitability. The wording of Part Suitability, as currently enforced, is even more stark. So that's in the following tab, tab 14, page 231. So the 4th paragraph, I think that is below the heading, beginning where a person has settlement and is in country, not including at the UK border, so where they're not abroad, where they're not abroad or at the border. So where a person has settlement and is in country, their permission can only be cancelled on the grounds contained in section 76 of the 2002 Act. That's leaving aside deportation, which is obviously dealt with in a separate section of the rules. So according to that, there's no power, no other power outside the statute. There's no incidental power, there's no ancillary power. That's the understanding of the law which the Secretary of State communicated to Parliament, and on the basis of which Parliament must be assumed to have been operating on the principles in Albie and in George when it approved those rules. But it's directly contradicting the position that she's advancing to this court. As to caseworker guidance, my learned friends say in their skeleton, paragraph 74, I think it is, that it's not significant that there's no caseworker guidance on the existence of this alleged ancillary power. I mean, I accept the point so far as it goes, that the Secretary of State isn't required to have policies on literally everything. But first of all, that needs to be seen in the context of a situation where the current rules expressly deny the existence of the power that she claims to exist. And secondly, it's striking that she does have policy guidance on revoking ILR, which makes no mention of any incidental power outside section 76. If we look at that policy guidance, it's bundle 2 of the hard copies, tab 43, page 874. 874 where it begins. You can see that it's headed revocation of indefinite leave, section 76, and exactly confined to section 76, but that is sort of the point. Under Page 878, if I could just ask the court to turn there first of all. Page 878, under the heading Policy Rationale. So it expresses the policy objectives behind the power to revoke in terms which don't include correction of mistakes. Page 884, under the heading at the top of 884, minded to revoke indefinitely, if it provides for people to be given prior notice of their intention to revoke under section 76, and chance to make representations on why ILR shouldn't be taken away. Remarkable, there's no equivalent process for the appellant situation. Seems to be accepted, I think, by my learned friends that, for example, the Secretary might not be able to take away ILR if there'd been detrimental reliance on his on the grant. But it seems that people in the appellant situation don't have the opportunity to explain what detrimental reliance they might have had, and the appellant didn't have it. So, on the Secretary of State's case, people who've committed offences or deportation, or have brought the revocation of ILR on themselves, as the Secretary of State would put it, by their actions, by use of deception, or by doing things incompatible with being a refugee, are in a better position than somebody who's entirely innocent. And then 894, under the heading Available Information, after setting out that ILR may be withdrawn, for example, where there's been deception, in the paragraph just above the next subheading, so just above exceptional circumstances, Secretary of State tells their caseworkers, in cases where a person honestly provided information in support of their application and the decision maker had the authority to grant leave, but for example overlooked that the applicant didn't entirely meet the requirements of the immigration rules, the applicant can't be said to have used deception, and therefore the power to revoke indefinite leave under section 76(2) can't be used. Now, it's obviously not a dispute that that's correct, that section 76 can't be used in those circumstances, but what is conspicuously is absent from that is any suggestion that there is, however, a power outside section 76 which they could use, which the caseworker could use to cancel or withdraw ILR on the basis of an error. One might think it would be worth mentioning to her caseworkers at that point in the guidance, if nowhere else, that they are entitled to take away ILR on the basis of mistake. Otherwise, how do they know that the power exists? How and in what circumstances and according to what process should they exercise it? How do applicants know that this power exists? Or what safeguards they've got against its use? It's like the proverbial tree falling in a forest where nobody can see it or hear it. So, as I say, there's nobody saying, I'm certainly not saying that there needs to be an entire separate policy explaining the power that the Secretary of State is contending for, but it is highly relevant. We say that the Secretary of State's caseworkers are nowhere told of its existence, not in the rules, not in the policy guidance, specifically addressing these circumstances, in which the Secretary of State is now saying she might want to exercise it.
So it's a speaking silence.
Indeed. And then moving on to the relevance of previous case law, paragraph 73 of our skeleton. Perhaps I can ask the court to turn up what Lord Jones says in the case of Robinson. So this is tab 2 of the authorities, bundle 2 of the authorities, tab 34, page 658, please. And the passage I'm relying on, I'll come back to the context in a second, but just to flag up the passage I'm relying on, it's paragraph 62, line 3, where Lord Jones says in very broad terms, Parliament is normally presumed to legislate in knowledge of and having regard to relevant judicial decisions. Now, I respectfully don't accept that principle is as narrow as my learned friends are suggesting in their skeleton. I don't accept that it's limited to the meaning of words and phrases, as I understand you contending. although the meaning of words and phrases is undoubtedly an aspect of it. We can see that the way that Lord Lloyd Jones expresses himself there is in broad terms. And then looking at the context in which his lordship expresses that principle. So the case is essentially about whether amendments to the 2002 Act, introduced in 2014, meant that there was a right of appeal against a refusal of a human rights claim, even if it was a repeat claim, and even if the Secretary of State had not accepted it as a fresh claim within the meaning of paragraph 352 of the rule. So the previously accepted position has been that there's a paragraph of the rule which acts as a kind of gatekeeper to whether you get a further right of appeal, as I'm sure the court is familiar with. So if we go back to page 656, please. Paragraph 58. So we can see that the argument being addressed in this part of the judgment is that the 2014 amendments to the appeals provisions have, at the end of line 2 of paragraph 58, affected a fundamental change in the operation of the statutory scheme, with the result that whatever may have been the position after BA Nigeria being a previous decision of the Supreme Court on appeal rights and fresh claims, Rule 353 no longer applies, and accordingly no longer performs a gatekeeper function. So as I say, the argument there is that there's been a complete rewriting of the appeals provisions, so that the immigration rules no longer play a part in determining who gets a right of appeal. And so 3 reasons are given for that by Mr. Fordham, as he then was. At 59, he says, he discusses the definition of the phrase human rights claim, and Lord Lloyd Jones essentially rejects that argument over the page at 657 in the same paragraph. I'm passing over these quite quickly because it's just about context. In paragraph 60, second part of Mr. Fordham's argument is a slightly wider point about the structure of the appeals provisions in the amended Act. Again, rejected in the same paragraph 60. And then 61, page 658. Thirdly, Mr. Fordham makes a series of submissions relating to the intention of Parliament in enacting the 2014 amendments, including at line 4, that if it had been the intention, line 5, to maintain the structure for which the Secretary of State contends, the structure of appeals, Parliament could be expected to make that clear, but the contrary is the case, he says. And so it's that submission that Lord Lloyd Jones is responding to when he says at paragraph 62 that this fails to take account of the principle of informed interpretation and the fact that Parliament is intended, is presumptively assumed to legislate in the knowledge of judicial decisions. And then he refers at line 6 of 62 to the judgment of this court in ZA Nigeria, which he says had provided an authoritative explanation of the effect of BA Nigeria in the Supreme Court. And then he says at line 8, just above F, as Sir James Eadie, Queen's Counsel, put it in his submissions, Parliament can therefore be assumed to have legislated in light of a consistent line of authority which established that a purported human rights claim that didn't meet the threshold of a fresh claim under Rule 353 wasn't a claim at all. Had Parliament intended to depart from this approach, it surely would have made express provision to that effect. So it isn't just the meaning of words and phrases attributed by the courts which Lord Lloyd Jones is addressing here. It's the court's understanding of the entire appellate structure within which those words and phrases appear. So we say the principle that he enunciates there, his lordship enunciates there, that Parliament is presumed to legislate in the knowledge of relevant judicial decisions, is a broad one. And I think it's not controversial, I'm sure, to say that there is a dynamic relationship between the courts and Parliament. The courts obviously interpret legislation, and if Parliament doesn't like the interpretation that courts have given, it can mend the legislation. And that obviously applies not just to words and phrases, it applies to wider matters, to the existence of powers or the non-existence of certain powers. And obviously that if, well, I say obviously, but certainly in my submission, if Parliament chooses not to override the court's interpretation of the law, despite having the chance to do so, importantly, then it can be assumed to be happy with that interpretation, with the court's interpretation. And particularly if Parliament has declined to legislate in a particular way, or has declined to provide particular powers when legislating in the area under discussion, that's relevant to whether it intended those powers to exist or not. And we say that Parliament must be taken to have known, since at least the decision in Ram in 1978, that a grant of ILR made on the basis of a mistake would be taken by the courts as valid, must be honoured, indeed must be honoured permanently, because nobody is suggesting there or elsewhere that it could be taken away, unless the person is subject to deportation. But despite legislating frequently, some would say constantly, in this sphere, it's never stepped in to legislate, to give the Secretary of State the power to withdraw such a grant. My learned friends say, well, it isn't necessary to legislate because there's an ancillary power, which, as I say, implicitly on their case has existed for more than 50 years without being detected, since commencement of the 1971 Act. They also say in paragraph 72 that Parliament has only ever stepped in to prevent a person benefiting from a grant of ILR where there was deliberate conduct on the part of the applicant, which justifies the Secretary of State responding by cancelling or revoking the leave previously granted. But there is an example, in fact, of Parliament stepping in to amend a provision under which people could get ILR effectively by accident without deliberate conduct, and that is the change in the law which is described in the case of Minton, which I said I would return to, and I would like to do so now, if I may. And it's Bundle 1, tab 19, page 300. If you look at this earlier, obviously, to the approach of the court to the meaning of section 4 of the Immigration Act. But we can see at the bottom of 300, Mr. Minton's an American citizen. Top of page 301. What happens is he arrives in the UK on 2 occasions in fairly quick succession in 1987. Second occasion is line 3 of page 301, 6th of August 87. At line 6, the stamp put in his passport on that date is not wholly legible. Obviously, this is back at a time when people didn't get electronic evidence, or they didn't even get stickers in their passports. They got a physical ink stamp placed in their passport. And page 302, Lord Justice Glidewell sets out the law as it then was in 1987, at the time Mr. Minton arrived. So in the indented paragraph about 2/3 of the way down, paragraph 6 of Schedule 2 of the 1971 Act, a provision that essentially, if someone's not given notice granting or refusing leave to enter within 12 hours of the conclusion of any examination by an immigration officer on his arrival, he shall be deemed, last 3 lines of the intended paragraph, he shall be deemed to have been given indefinite leave to enter.
Even though there was a condition attached, no employment, which can only be attached to limited leave.
No, there wouldn't have been any.
Well, if you look up at the bit that you asked us to leave after the 6th of August, wasn't wholly legible. With difficulty, it's possible to make out the words leave to enter and then months. Below, the words employment prohibited are legible. So it could only have been limited leave that he got.
Well, that was the Secretary of State's contention, but it's not accepted by the courts for reason which let me come on to. Mr. Minton, what Mr. Minton says is that he hasn't been given valid notice because the end date on his leave isn't.
No, well, that may be a different point, but if you've got a prohibition, as you rightly pointed out, under Section 3 or whatever, you can only have that when you've got limited leave.
Well, indeed, and that might have been a reason for thinking that he had only got limited leave. But the conclusion of the court is that he had. Conclusion of the court is he had got ILR, constraining the provisions as far as they could, because the basis on which he got ILR was not the stamp in his passport. It was the fact that he hadn't been given proper notice of his leave, and therefore he hadn't been given proper notice of his leave within the 12 hours allowed for, and therefore he gets ILR by default, effectively, by accident.
By the effect of this deeming provision.
I beg my pardon?
By the effect of this deeming provision.
Indeed, yes. So it's not about what the stamp says, it's about the fact that the stamp can't be read, and therefore it's accepted, not as it happens by Lord Justice Gladwell, but by the other members of the court, the majority of the court, that he's acquired ILR effectively by mistake, not because of the wrong template being used, but because his passport was stamped in a deficient way. But what's relevant for purposes of this argument, and the current argument, is that all three members of the court do point out that in 1988, so after the events surrounding Mr. Minton's arrival, but before the hearing in this court, Parliament stepped in to change the provision deeming ILR to have been granted. So, page 304, what Justice Glidewell says about halfway down the third full paragraph of the page, as has been made clear to us, paragraph 6 of Schedule 2 of the 1971 Act has been amended by provisions of the 1988 Immigration Act, into force on 10th of July 1988. 1988 Act provides a period within which an applicant for admission to the UK must be given notice of 24 hours, so an extension, and if he's not given notice within that period, he's deemed to be given limited leave to enter for a period of 6 months. And that amendment is also noted by Lord Justice Russell at the bottom of page 305, and Lord Justice Crouches at page 307, paragraph above where it says order. So essentially from July 1988 onwards, a person in Mr. Minton's situation wouldn't get ILR by mistake. They would just get 6 months leave. So what we see there is Parliament stepping in to prevent a certain category of person from getting ILR by accident, even though it's through no action or inaction of their own. So if my learned friends are right, that there's already a power incidental to the 1971 Act to enable the Secretary of State to take away ILR granted by mistake, as effectively was the case in Mr. Minton's situation. Not obvious why Parliament needed to do that. Indeed, the deeming provision, the very existence of the deeming provision granting ILR would be entirely superfluous if the Secretary could then just turn around and say, well, you haven't got it, we're taking it away. Indeed, that would seem to be contrary to what it would seem to point in the opposite direction to the current existence. We did, if it will assist, we did print off copies of the legislation both before and after the 1988 changes, which we can hand up, but that they are obviously set out in the judgment. So, with respect, my learned friends aren't correct to say that no statutory intervention is needed to correct an accidental grant of ILR, because that's already happened at least once already. They're also not correct with respect to say that Parliament had only ever stepped in where there was deliberate conduct on the part of the applicant, because again, Mr. Minton had not deliberately contributed to his windfall, as I put it earlier. And the fact remains that Parliament has not stepped in again since then to address the situation of people getting ILR in other ways by accident. Nothing Parliament has ever said or done, when it's legislating, when it's approving the rules, is consistent with a recognition of the existence of this kind of ancillary power. Indeed, as I say, nothing the Secretary of State has ever said or done before this case, in the rules, in her policy guidance, is consistent with the existence of such power. Now, whilst I would accept in general terms what's said by my learned friends in their skeleton at 69, with reference to Benyon and other matters about there being numerous reasons why Parliament might not legislate in a particular way or at all, this is a situation, as I've hoped to demonstrate, where Parliament has legislated on this very topic. We do have a material amendment to the circumstances in which ILR can be taken away in section 76, in which Parliament has obviously legislated for limited circumstances, not including errors by the Secretary of State. Stepped in, as we've just seen, to provide a power which didn't exist. Sorry, no, I'm reading ahead of myself. It stepped in section 76 to provide a power which didn't exist on the face of the 71 Act, to take away leave granted on the basis of deception, didn't legislate to enable revocation of ILR on the basis of mistake, and we say if Parliament had intended it to have that, intended the Secretary to have that power, then it would have said so. And I've referred, we referred in 74 to judgment in Hedges and Butler, which is Authorities Bundle 1, tab 18, page 287. This is a case to do with the extent of the powers of the Customs and Excise Commissioners to inspect business records. And the relevant passage is at the bottom of page 294. Last three lines of 294, Lord Justice Mustill says, the legislature took the trouble to amend the existing legislation to add a new power to require the company to keep, preserve and produce a series of records, defined in a narrower sense. If the legislature really meant the records to be preserved and produced were understood in a wider sense, why not say so? And then line 5 of that page, page 295, the legislature was persuaded that the commissioners needed some specific new powers. It conferred them specifically. There's no power, no ground to suppose that there were also conferred silently some indefinite wider powers. I've cited in 75, the case of Akawushala. I don't think I will add to what I've said there. 76, as to the question of detrimental reliance by Mr. YC following his initial grant of ILR, the absence of which was given weight by the tribunal. With respect, we say the tribunal essentially approached matters from the wrong angle. The previous cases have hinged on not on whether there's been reliance by the individual, so that it would be unfair to withdraw it. The previous cases have hinged on whether the mistake was induced, so that it would be unfair to allow them to benefit. So the default is taken to be that they should benefit, they're entitled from the mistake unless there's a reason not to. The tribunal has got that the wrong way around. And as we've said at 77, the tribunal's judgment marks a departure from the previous case law on the inherent power of authorities to correct their decisions. Those largely seem to hinge on power to do so in the event of a fundamental mistake of fact. The tribunal agreed that that was absent in this case. The Secretary of State has not pointed either the tribunal or, as far as I'm aware, this court to any authority to the effect that a decision which isn't ultra vires, isn't induced by deception, isn't based on a mistake of fact, can simply be withdrawn without express statutory power. So we say that there's no basis on which the court should step in to identify this incidental power, separate from the power to revoke or curtail, and, as I say, previously undetected by anyone. As to the consequences described by the tribunal, paragraph 57, which we looked at, so the tribunal was concerned that a serious criminal might be granted ILR by accident, and the Secretary of State would have no power to correct it, and they referred to the possibility of people in similar situations being treated inconsistently. We say those, with respect to no reason for concluding against us. First of all, Section 5 of the Immigration Act, which we refer to, does prevent leave being granted to a person against whom a deportation order is enforced. So somebody who's committed serious offences would be subject to deportation in the ordinary course of events. For your note, I don't think we need to go back there unless it will assist, but it was page 38 in tab 1 of the authorities. a deportation order against a person shall invalidate any leave to enter or remain in the UK given him before the order is made or while it's in force. Maybe, I don't know, that Section 5 wasn't drawn to the Tribunal's attention, but that clearly shows, we say that an accidental grant of ILR to a person against whom a deportation order is in force is invalid by force of law. So it wouldn't have to be on them. And equally, if the accidental grant of ILR were made before the deportation order, then it would be invalidated prospectively on the subsequent deportation order. So the spectre raised by the Tribunal and by my learned friends of criminals having to be allowed to remain indefinitely in the UK and nobody being able to stop them is with respect to an illusory one.
Might also be thought that the remedy lies in the Secretary of State's own hands.
Well, indeed, and we've made the point, I think, that these are important powers which have...
Should be exercised with care.
Indeed. And as to any other risks, well, if Parliament thought that those risks were significant, it's always had the power to address them. And of course, as I say, we have the Secretary of State's indication that these mistakes are rare. Broadly, I'd accept that. I think probably I would say they happen a little more often than the Secretary of State might be prepared to admit, but nobody's suggesting that they happen all the time, and Parliament has always had the power and still has the power to address them. So yes, indeed, further down our 79, I've made the point my lady has just made about the importance of exercising powers with great care, and we would respectfully say that even though the circumstances in which the Secretary of State might exercise the power to withdraw, if she's got one, so she doesn't, but even if the circumstances in which the Secretary of State might exercise such power would be subject to doctrines such as legitimate expectation and detrimental reliance and so on, that doesn't assist the average person in receipt of a letter from the Secretary of State, because they can't possibly know when or whether their leave might be taken away on the basis that it was granted by mistake. They can't possibly know how they can regulate their own conduct, let alone third parties, their employers, their landlords, their family members. How can they know whether the leave might be suddenly taken away? And so the existence of public law constraints on the Secretary of State's power is not, with respect, an answer. So we say the present state of the law, in fact, the present state of the law, some people benefit from a windfall of this sort. That is a price for maintaining, a price for avoiding a situation where a much larger group of people, as well as third parties, simply can't rely on the decision letters that have been given. Third point is no power of retroactive cancellation. I think, as I say, I can be brief here because I don't think my learned friends dispute this as a point of law. They obviously say it isn't what happened, but essentially we say the grant of limited leave wasn't expected to take place only prospectively, was backdated, and that shows, we say, that it was clearly intended to replace the grant of ILR. Otherwise, the Parliament would simultaneously have had limited leave and indefinite leave, which isn't possible. As I say, the Tribunal doesn't clearly indicate what it thought on this point. The better reading of its judgment, we say, is it did work on the basis that it took effect retroactively, and if that's right, then that's another reason why it was wrong to conclude the power which it identified did exist. And there are very good reasons, as I've set out at paragraph 84 onwards, which seems my learned friends don't dispute. There are very good reasons why a cancellation of leave can't take effect retroactively because of the creation of legal uncertainty in an area where certainty over people's status, both for the individuals themselves and for third parties, essential, and where the consequences of not complying with leave are extremely severe. Part of that third point, and then our final point, beginning at paragraph 92, is essentially that these powers are not incidental powers anyway. Now, obviously we don't dispute, at a general level, Tribunal's acceptance that the Secretary of State, like any other public authority, has incidental powers. That there are powers which aren't expressly granted by Parliament, but which are reasonably incidental to those powers. The question, obviously, is the extent of those powers. My learned friends rely on New London College, which I'd like the court to go to now. We say essentially New London College isn't authority for the proposition for which they cite it. It's bundle 1, tab 29, page 488. And we can see from the headnote, page 488, that it concerns a system where colleges, education establishments are granted a sponsor license, enabling them to enrol non-UEA students. And the challenge by the claimants is to the failure to incorporate the relevant criteria for a sponsor license in the immigration rules. That's basically their claim. There are also interveners, whose submissions we'll come on to look at. Interveners make a still more far-reaching set of submissions. They say there's no power at all to do this. And Lord Sumption gives the majority judgment. For the context of what he says about incidental powers, perhaps we could start at page 499, paragraph 24. So, paragraph 24, just below F, Lord Sumption says, I would readily accept that the mandatory criteria for the award and retention of a sponsor license are rules, but subject to one reservation, which isn't important for our purposes. They're not rules calling for compliance by the migrant as a condition of his obtaining leave to enter or remain. The sponsor guidance is wholly concerned with the position of the sponsor, i.e. the college. So the entire case is not about powers to grant or refuse leave to remain. That's the most important point to start with, I think. And then turning to page 501, this is addressing the submissions of Mr. Drabble, Queen's Counsel, for the interveners. So the interveners are, as we see at 26, arguing that, 27, he's saying that there's no power at all to have such a system. Again, as they're quite long, perhaps I could just ask the court to read 27, 28 and 29, please. Should I continue?
Sorry, did you want us to read 29? I haven't
Oh,
quite
yes,
finished
please,
it.
sorry.
No, sorry, I'm a slow reader. Thank you. Yes, thank you.
Thank you. So Lord Sumption is distinguishing, we say, between, on the one hand, powers to regulate entry and stay, i.e. to grant or refuse leave to enter or remain. On the other hand, what he calls purely managerial acts, or administrative measures, into which category he puts the power to issue sponsor licenses. So that this is the only case cited by my learned friends in support of the existence of incidental powers in this particular context, in the immigration context. And it is authority, we say, only that the Secretary of State has power to do purely managerial or administrative acts, separate to the grant of leave or the refusal of leave. Doesn't support, certainly doesn't actively support, the existence of a previously unidentified incidental power to take away leave. Now, except that in that passage he doesn't, his lordship doesn't close off the possibility that the Secretary of State's incidental powers could extend to granting and refusing leave. But is there authority which suggests that incidental powers might be able to go that far? Well, we say not.
It's unlikely. It's unlikely that he really meant that, because he's distinguishing Alvi on the basis that Alvi is saying you've got to have express provisions in the rule where they establish conditions for getting leave, and he's saying this kind of thing isn't in that box. It's in a different box. It's just an administrative power that affects third parties, not finance.
Yes, I mean it's certainly in our favour that far. I suppose all I'm saying is he doesn't expressly say. I don't think he expressly says that there's no incidental powers,
yeah.
But he's certainly leaning against them. Yes. Yeah. I just wanted to look then at a couple of cases about the thresholds for the existence of incidental powers. One of them is the decision of the Privy Council in Commissioner of Investigations. So that's tab 36, bundle 2, tab 36, page 668. So essentially the Commissioner of the Independent Commission of Investigations in Jamaica had the function of investigating deaths and injuries at the hands of the security forces. And the question was whether the Commissioner had a power to prosecute officers who had allegedly killed or injured people, despite the lack of any statutory provision to that effect. So obviously these people had committed offences, or allegedly committed offences. The question was who prosecuted them? Was it the Commissioner? And page 691, paragraph 40, Privy Council says, the absence in the present case of an express power to do anything that's calculated to facilitate or is incidental or conducive to the carrying out of the Commission's functions isn't fatal to the Commission's reliance on security plan. Security plan is a case where the power to prosecute private security firms in the UK was found to exist. And Lord Jones, I think it is, says, this is because in appropriate circumstances powers may be implied. Whether such implication is possible will depend on the particular circumstances of each statutory scheme. In particular, the express functions conferred on the statutory body, it is not possible simply to transfer the reasoning from one statute to another. So a fairly high threshold. The court ends up concluding that the Commission does have some powers to prosecute. So it doesn't have the powers to prosecute for deaths and injuries, but it does have the powers to prosecute for obstruction and misleading the Commission itself, because those are held to be incidental to its own powers. That's paragraph 43 and 44 of the court's note. I don't think we need to go there. It's the general point of principle that I wanted to flag up. So we say that's fairly high threshold for reading in incidental powers. Also consistent with the case of Hazel, we referred to at 95. This is bundle 1, tab 20.
Before we leave this, where do you say Lloyd Jones articulates the test? Which paragraph?
Well, Well, sorry, it's first of all the point being made about that it's all dependent on the statute.
Yeah.
Paragraph 40. And then, well, perhaps I should just look at 43. 43 on 692. So a power to prosecute for incident offences. Incident offences is obviously shootings and injuries and deaths. Power to prosecute for incident offences is not an incident of, ancillary to, or consequential upon the Commission's statutory function, nor does the Commission require such power in order to be able to effectively discharge its statutory function, which the Act makes clear as an investigative function, wouldn't facilitate the discharge of that function, or in any way enhance the fulfilment of the Commission's duties. There's nothing in the 2010 Act to suggest that it was intended that the Commission should perform any function in relation to prosecution of incident offences. As a result, the implication of the powers contended for becomes an impossibility. So that's the powers to prosecute for the actual primary offences, so to speak. And then 44, the Lordship says it's common ground, and he agrees that offences of obstruction or misleading the Commission itself may be prosecuted by the Commission. So the last couple of lines of page 692, it's not disputed that the prosecution in respect of an offence under section 33 is capable of aiding the Commission in the discharge of its investigative functions. The Commission therefore has an implied power consistent with the express terms of the Act to bring prosecution for misleading or obstructing offences. Concession correctly made. Each of these offences is very closely related to the investigative functions of the Commission, intended to promote the effective performance of those functions, by contrast with the general power to prosecute for offences which form the subject matter of the investigations. Power to prosecute is conducive and properly incidental to the effective performance of the Commission's investigative functions. Offences created in order to promote and protect the Commission from obstruction in the performance of its investigative function, and the necessary implication is quite clear that the Commission should have power to prosecute in respect of such conduct. So stressing the need for these to be incidental to the effective performance of the primary function of the Commission. And then similarly to that, Hazel, Bundle 1, Tab 20, page 340. And this is a case about whether a local authority, having borrowed large sums of money, was empowered to enter into interest swap contracts. I'm not going to pretend I know exactly what those are, but by D we can see that the authorities deal with, page 3, yes, page 340 by D. The authorities deal with widely different statutory functions to establish the general proposition that when a power is claimed to be incidental, the provisions of the statute which confer and limit functions must be considered and construed. And then by E, just below E, a power is not incidental merely because it's convenient or desirable or profitable. Now, my then friends have prayed in aid here and below a number of cases in support of their contention that an incidental power to correct a mistaken grant of leave must exist. And we say, with respect, the most fundamental answer to those is the one given in both the independent commissioner case and here in Hazel, i.e. the statutory context in all of these cases is different. Indeed, the one cited below, additionally, the one cited below, as the tribunal observed, all appear to revolve around mistakes of fact. I've addressed the ones below in our skeleton at paragraph 90. Unless it will assist, I don't propose to add anything to that. But essentially, these are all cases in a specific context revolving around a mistake of fact. And the tribunal didn't find those cases at all helpful. as to the existence of an otherwise undetected power of correction in respect of a grant of leave, and we say it was correct to take that view. Additionally, my learned friends have now cited a case called Vote Leave, and we have that in bundle 2 of the authorities, tab 36, page 660. And this is, as we can see, a challenge to the Electoral Commission, and we can see from the head note, line 4, that the Electoral Commission had a statutory function, has the statutory function of monitoring and ensuring compliance with the statutory rules that apply to the financing of referendum campaigns. And so the challenge is then the publication of a report on its investigations into the Vote Leave campaign. Obviously, a very, very different. So there's no dispute the Commission had power to investigate the Vote Leave campaign. The objection being taken is to publicising the outcome of those investigations. And it's perhaps not very surprising, we would respectfully suggest, that this court finds page 664, paragraph 22, that the publication of the report was within the Commission's powers because it was incidental to the carrying out of its enforcement functions. And then 24, making a public report on how those functions have been performed in a particular case can, in my judgment, possibly be described as incidental to their carrying out. Again, simply publishing a report into something you've already done, you've already lawfully done, are very different matters to taking away someone's rights. And of course, it's very important in this particular case, as all the cases stress, to see this particular outcome in Vote Leave in its proper context. And the proper context of Vote Leave is the integrity of the electoral process, electoral and or referendum process. Obviously, a matter of almost incalculable public importance. So very, very, very different.
Was a test articulated in that?
I'm not sure it was particularly, my lord.
Paragraph, there's a reference in paragraph 22 of Lord Justice Arnhill's judgment to paragraph 2 of Schedule 1 to the Act. What does that say? Is that an express incidental power?
Paragraph 2 of Schedule 1 is set out at paragraph 10 on page 662. So that's a general.
Oh yes, so it's like section 111 of the Local Government Act, which was the provision that was being construed in Hazel.
Yes,
Does it wear an express power to do things which are yes, so and in fact there's a reference in the next sentence to section 111. Yeah. That's
and indeed, Lord Justice Underhill says at the bottom of that paragraph that's just codifying what's long been recognised to be. Yeah. Just to respond to a couple of other points raised by my learned friends in their skeleton. My learned friends have quoted praise on legislation. This is a textbook whose relevant passage appears in bundle 2, tab 46, page 1017. So the passage, if I recall correctly, was quoted is at 12.020, where a statutory function is conferred on the minister or any other person it's implicitly may do anything necessary for the performance of that function. If the function is conferred in very broad terms, the power available for performance will be implied in very broad terms. But perhaps also worth looking at the next paragraph, which I think my learned friends didn't quote, which says the more detailed the statutory provisions are as to how the function confers to be exercised, the slower the courts will be to grant the implication of powers to supplement the details of the statute. Obviously, we say that's here. And then it quotes from a case called Credit Suisse and Waltham Forest Council, where Parliament has made detailed provisions as to how certain statutory functions will be carried out with no scope for implying the existence of additional powers which lie wholly outside the statutory code. Again, obviously, we say that's this position. My learned friends also quote from Wade and Forsyth in a passage beginning at 1019, tab 47, page 1019, to the effect that the doctrine of incidental powers is not applied narrowly, which is right at the bottom of the main text on page 19. But it is perhaps interesting to note that the examples of incidental powers which are given over the page, in fact in the last line of 1019 and over the page on 1020, are matters such as a local authority doing its own bookbinding, or providing insurance to its tenants, or a housing authority providing insurance to its tenants. Matters obviously of a very different order to improving the right of somebody to live in this country. So there's I would suggest very much more, if there is a comparison to be drawn, very much more to the purely managerial functions of which Lord Sumption was speaking in London College. And then just one more authority on this point, Hedges and Butler, which we already looked at, but just if we could just look again at page, bundle 1, tab 18, page 294. This is the Customs and Excise case again, what records the Customs and Excise were interested to look at. Lord Justice Mustill, that between G and H, he cites judgment of Viscount Dilhorn in Damon or Garland and Southwest Water Authority to the effect that the supplementary power is, in the indented paragraph, something added to what is in the Act to fill in the details or machinery for which the Act itself doesn't provide, supplementary in the sense that it's required to implement what's in the Act. And then he says by J that the power that the commissioners were contending for, just above J, does not fill in details or machinery for the purpose of implementing what was in the statute. It creates a new and radically more extensive set of powers.
I'm so
coming
sorry,
back to
which page are you on? It's my fault.
I'm so sorry, page 294,
294, thank you very much.
between G and J. So coming back to this case, we say that the power to withdraw a grant of ILR is not incidental to the Secretary of State's power to grant ILR. The former doesn't facilitate the latter.
It negates it.
Leaving aside a position of fraud, possibly, it doesn't make the power to take away leave doesn't make the power to grant leave work more effectively. It's not a question of machinery. I accept. I'm prepared to go so far as saying that power might well be convenient or desirable for the Secretary of State, but that is insufficient. On the contrary, we say the power to withdraw or revoke ILR is a contrasting power. It's what Lord Justice Mustill here in Hedges and Butler calls a new and radically more extensive power. It's a power which would enable the Secretary of State not to implement the statutory power, but to sidestep it, particularly the Section 76 power. And there's no authority at least none that's been cited by my own friends, for the notion that the existence of a statutory power to do a certain thing necessarily implies the existence of a power to do the exact opposite outside the statutory framework. Indeed, such authority as we have indicates that there is no such power. Again, Parliament could have legislated, didn't. As I say, from the outset, the 1971 Act doesn't make any provision for ILR to be taken away save by deportation, doesn't envisage that there's an implicit power because there's no right of appeal. The rules approved by Parliament have never envisaged the existence of such power. Indeed, the current iteration of the rules expressly excludes it, nor has any court ever identified such power before this case. Previously entirely undetected power, in effect. So we invite the court not to accept the Secretary of State's arguments that it exists. Now, I'm conscious that I haven't answered my Lord's question about the difference between withdrawing a negative decision and withdrawing a positive one. I wonder if I might just think about that as a short adjournment.
Of course. I mean, whenever's convenient.
Well, that's a convenient point for me to stop, if I may, and then perhaps I could come back with an attentive answer.
Thank you very much indeed. Is there anything further? No. Thank you. Ms. Smith, is there anything further you wanted to add? Thank you. Mr. Blundell, you were happy to start with?
Yes, of course, very happy to start.
Thank you very much.
Rearrange my papers for a moment. And if it assists the court, can I take things in 4 stages? So I'll outline what they are now and perhaps get through stage 1 before lunch and maybe even start on stage 2. So first of all, I'll set out the Secretary of State's case in a nutshell so that you know broadly where I'm going. Secondly, I want to make some brief remarks on the facts. You've seen some of the background to decision making here, but I want to take you through also the background to the kind of application being made, what was being requested and what could be granted, because that in my submission is also part of the important context here. Thirdly, I'll make some brief remarks and take you to some of the provisions of the relevant immigration rules to do with, again, the kinds of grants of leave that were an issue here. And then fourthly, I'll respond to the submissions focusing on the primary question, is there an incidental power to withdraw a notice granting ILR where it's been granted by administrative or clerical error? And I'll deal in turn with my learned friends' objections to our suggestion that there is such a power. So can I begin then with, if you like, stage 1 of my submissions of the Secretary of State's case in a nutshell? Can I summarise it in this way in 5 points? First of all, and we say this is an important starting point, the existence of incidental and ancillary statutory powers in public law generally is well established, uncontroversial, and not indeed, we say, seriously in dispute as a matter of principle here. I accept, of course, the point that you can't simply transfer a proposition from one area of public law to another. You have to look at the statutory context, and I'll do that in due course. But the starting point is an important one. The case, we say, is not quite as radical as it's being suggested that it is here. There are other areas where powers to withdraw important decisions with consequences have been recognised in public. Secondly, and similarly, the existence of incidental and ancillary powers, the statutory powers in the immigration field specifically, is also, we say, well established, uncontroversial, and not seriously in dispute. There may be, and there is, obviously some disputes about precisely how far the judgment in New London College goes. In my submission, what one can't dispute is that there is a recognition of the ability to imply incidental powers into the provisions of the Immigration Act, and that again is a critical starting point for the argument. As to that, thirdly, the particular situation here is that the claimant was issued as a result of an administrative error, and again, let me be absolutely clear, the Secretary of State's error. So this is not a case where this claimant has done anything wrong, we accept that, but with a letter apparently granting him ILR, for which he had not applied and to which he was not entitled. Indeed, it might be noted that even on the application for asylum, which was the primary focus of his interaction with the Secretary of State that he did make, he was not entitled to ILR. He was entitled to a period of 5 years. So he was never looking at or seeking to obtain indefinite leave to remain. In that sense, then, this was, in immigration terms, the ultimate windfall. There is no greater immigration right, leaving aside issues of nationality, of course, than indefinite leave to remain. Fourthly, in those circumstances, we do say that there is an incidental or ancillary power in the 1971 Act to withdraw the decision letter that had been issued and replace it with the correct decision notice that actually implemented the decision maker's intention. We say that's a power which is reasonably incidental to the section 3 and 4 primary powers to grant leave in its various forms and to do so by notice in writing. And it enables the proper exercise of those powers to be respected. It ensures that the correct form of leave is granted to those who are entitled to it and not to those who are not. And by doing so, it ensures the integrity of the statutory immigration scheme.
But I mean, shouldn't the public be able to rely on the Secretary of State to get it right first time?
Well, I can't dissent from that proposition, of course not. And there are mistakes that are made by the Secretary of State, just as there are mistakes made by many public law decision makers. I'm going to show you one or two of the other ones as well. But what that doesn't mean is that the mistakes have to bind the public and the public interest, because there are two sides to the public there. There's the private interest, of course, of the member of the public who receives the decision notice, but then there's the wider public interest where people are granted leave under the Act to which they're not entitled, and whether or not the Secretary of State should be entitled to do something about it. Now, of course, the case put against me is, well, when that's necessary to do, Parliament has legislated for that purpose in Section 76, and I have to meet that, and I will come back to that and deal with that in due course. We say there is a fundamental distinction with Section 76, which is a parliamentary intervention into the field where there is something wrong that an individual has done and there's no other reason to get involved. But the position with the incidental power to withdraw the notice is that it's an individual mistake on the part of the Secretary of State. The individual has done no wrong. And there is a line of cases in public law, in other areas of public law, demonstrating that in those in circumstances where there's a fundamental mistake, there are incidental powers to withdraw decisions. Now, if there is a power, we say, to withdraw for fundamental mistake in lots of other areas of public law, there is a hair's breadth between that and withdrawing for administrative or clerical error. In either situation, there need be no error on the part of the individual who has received the notice. And that picks up my lady's point about the public being able to rely on what the Secretary of State does. I can't stand here and say the Secretary of State has acted perfectly in this case. Plainly, that's not the case. And just to get this out of the way now, the point that my lady and my lords have raised about the date on the second letter, I've taken instructions on that. We've taken instructions already on that. My understanding is that the 8th of November date is a mistake. It should have been the 13th of November. Now, I'm going to come to retrospectivity in the event, but this is why I get it out of the way now. I'm not seeking to hide from that. This is not a case of impeccable decision making. If it was, we wouldn't be here. The question is what to do about it. And one has to face up to that in my position.
Well, that may be a convenient time to take the break.
It is. The only fifth point I was going to say, just so you have
sorry,
it.
no, I don't want to cut you short.
No, not at all. My lord's quite right to, given the time. It's only this. We say no unfairness here, because this was spotted quickly, dealt with quickly, and at all material times, the appellant benefited from the leave which he had already at that stage been granted. It ties into some degree to the ex parte ram and the retrospectivity point. I won't develop that now, but just so you've got it as a headline.
Good. Thank you very much. Well, thank you all very much, and we'll look forward to seeing you at 2 o'clock.
All rise if able. All rise if able.
Yes, Mary.
Yeah, think I just got to the end of my first stage before lunch, which was the outline of our submissions.
Yeah.
Can I move to stage 2, which is some background in the facts and decision making here?
Of course.
And for that, I say it's necessary to do that, particularly given the court's question yesterday about the legality of the decision. So the background, of course, as the court knows, the claimant applied for asylum. You don't have the original documentation before the court. So, for example, the screening interview, the substantive interview record, or any documents in support. But you do have a set of representations dating from the 16th of October 2023. Can I ask the court to turn those up? They're in the appeal bundle behind tab 34 at page 274. And you'll see that there's a letter from the appellant's legal representative on the 16th of October. You'll see under the personal details that they continue to act for him in relation to his immigration matters in the UK. There's a record then of him attending an asylum interview in September, and they got a copy of the interview record on the 3rd of October. And following that, they set out their submissions of further evidence in support of the application. If I can ask the court to turn over, you'll see at page 275, after a list of the various documents that have been provided already and provided with the representations, level with the first hold punch he entered, they say, in 2000 and claimed asylum in April 2019. There's an issue about what law applied. There's a reference to his background and his medical circumstances. And then on page 276, there's the asylum claim, which of course is the primary claim that he was making. That's then dealt with over the course of a number of pages. And you'll see then, if one turns to page 284, or the 283, you'll see the conclusion on the asylum claim. They make the point that he's established a well-founded fear of persecution for a refugee convention reason. Okay, I won't go through the details. It's then coupled on page 284 with an Article 3, essentially protection claim, towards the top of the page. And then, unsurprisingly, given the medical evidence they were relying on, they make an Article 3 ECHR medical grounds claim at the bottom of the page. And then there's some detail about how that's set out there. One turns then over to page 288. Conclusion on the Article 3 claim. It's said to be a real risk of breach. And then you have the private life claim. And that's the one that's obviously relevant for the proceedings today. Private life and Article 8 ECHR. You'll see he claims to have come in at that stage 23 years ago. And over the page, at the top of the page, you'll see the claim is then put in two ways. So at the very top of page 289, you submit as someone who has resided continuously for 20 years or more, he meets the requirements of PL, it's the immigration rule in Appendix Private Life, PL 5.1a, and ought to be granted. But if they're wrong about that, then they say he meets the requirements of the alternative limb, PL 5.1b, and I'll take you to those limbs in just a moment so you can see what that was about. If it's accepted he's lived in the UK since at least 2007, that's a very significant period, not been in touch with his family, now ill, unable to work, only support now work he has in the UK, likely homeless and destitute. And then you have the conclusion, meets the definition of a refugee for well-founded convention reason, and then alternatively, if it's not accepted that he succeeds on refugee grounds, please consider leave to remain on the basis of the health condition or the private life. Standing back from all that, what is the nature then of the application that he made? Well, it was first and foremost an asylum claim with related Article 3 arguments and with a fallback Article 8 private life claim. But what did that seek? That sought only leave to remain. It didn't seek, and that must be limited leave to remain, it didn't seek indefinite leave to remain. And when I take you to the rules, you'll see that it could only have been seeking a period of limited leave to remain. So at no stage did he articulate a request for indefinite leave to remain on any basis at all, not on asylum, not on Article 3, not in Article 8. And that we say is totally unsurprising. That is, in a sense, to the credit of his legal representatives who put it in the way that it should have been put. That led, of course, to the first incorrect status grant letter, which you've already seen, but perhaps I should take you back to. That's at page 239 of the same bundle, dated 30th of November. And you'll see it begins by saying your protection asylum claim has been refused, but you've been granted permission to stay based on your private life, reasons set out in the reasons bit of the letter. That is all identical with the correct letter that's then sent later. What is incorrect is the passage starting what this means for you. It says you've been granted settlement, also known as indefinite permission to stay in the UK, and then you'll see a link to what you need to know about settlement there. Going over the page, there's a decision record in relation to the refusal of asylum, and then the reasons in relation to Article 8 private life are at page 243. And you'll see it says family and private life. Decided to grant you permission to stay in the UK based on your right to respect private and family life under Article 8. Grant is based on your private life as an adult because it's considered there would be significant obstacles to you reintegrating in China. Again, the reasoning is identical with the subsequent replacement letter. And there's then a reference to the biometric residence permit being provided in due course. So the bit that's wrong is the passage dealing with what this means for you. That's where the incorrect template letter was set out. And to answer one question that came up in argument this morning, where was this set out in the Secretary of State's, if you like, evidence or pleadings or anything of that nature? It was set out in the detailed grounds of defence. There behind tab 24, paragraph 7 on page 190. Thought may just want to see that. You'll see at paragraph 7 there's a reference to the letter I've just shown you. The reference to the passage saying you've been granted settlement, and then it says this was a mistake. The decision maker did not intend to grant settlement, that is ILR, inadvertently selected the wrong wording template for that particular part of the letter and did not consider the applicant satisfied the requirements in respect of granting ILR, believing the letter would notify the applicant of a decision to grant limited leave to remain on private life grounds. Now that was never and never has been contested, so no evidence, further evidence was adduced to make good what is said by way of the pleadings, but that was said on instructions.
But so the person who wrote that letter didn't proofread it, didn't read it through.
That
They
must
can't
be.
have done.
No, I can't
So
suggest.
they believed the letter had done something it hadn't done. They could only believe that if they hadn't read what they drafted.
Well, that's right, but of course the point is they've selected a template. I entirely accept that must be right. If they'd read through the letter, they would have noticed that it wasn't doing that. However, the reality is they are dealing usually with very high volumes of cases. The templates are there to try and make the administration of the task easier. The downside to selecting a template, if you get it wrong, of course, is that you do the wrong thing. Now, I hope I made it clear before lunch. I can't stand here and say this was in any way an impeccable process of decision making. It wasn't. It went wrong. And it went wrong in exactly that way. But the question is, what's the consequence? And does that have to remain the case? Or is there anything that
Can I
be done?
just, I mean, it may be nothing to the legal thing, but I mean, given his medical condition, given your express concession that he's got substantial difficulties reintegrating into China, I mean, I accept that that is different from the legal point. What is the point of all this? Because he's never going to, whether you grant him 5 years or indefinite leave to remain, he's never going to go, is he?
Well, I'm very cautious about, as I always would be in these circumstances, about accepting that's necessarily true. I understand entirely why my lord puts the point to me, based on the facts of the case. The difficulty is things do change in ways that people don't expect. And so the rules are strict for a reason, and they're quite clear that for somebody in this category, what they get is a particularly limited period of leave. I'm going to show you the rules now in a moment, and it's effectively a mandatory period. Now you can, of course, grant ILR, but that would usually only be on the basis that somebody had specifically asked for it and made a case for that to be the case. The reason I took you to the 16th of October representations was to show you that this isn't one of those cases. This wasn't a case, and it can be contrasted with one or two of the other cases in the law reports, where actually the legal representatives are saying, look, come on, actually either he satisfies the requirements for leave indefinitely under the rules, or this is a wholly exceptional situation where you should grant what's called lotter leave outside the rules. And the criteria, to be absolutely clear, the criteria for indefinite leave, he did not satisfy and would not satisfy. It would have to be lotter, and that is a very, very high threshold. My lord will know, particularly, for example, from some of the Arab cases.
Yeah. And what about the 20 years? It was a slightly cryptic reference in the representations to 20 years.
Yes, perhaps I can deal with that by taking you to the rules.
Of course, yeah, whenever it's convenient. Thank you.
Yes, yeah, that might be the best way of doing it. So there is a dividing line in the relevant provision in the rules at 20 years, and the test is slightly different. Depending, it includes a requirement to show there would be particular obstacles in reintegration if you're less than 20 years.
Yeah.
So perhaps I can do that in just a moment. And just to close off the decision making before I do that, my learned friend referred rightly to the communications which then took place between the legal representatives and the Secretary of State. What happened was once the appellant received this particular, once he received his biometric residence permit, they noticed that there was a problem with it, and you can see that if one turns in the bundle to page 270. This is part of a chain of email correspondence. And you'll see on page 270, the bottom half of the page is an email sent from Southwark Law Centre on the 11th of December. We've received the attached decision stating our client has been granted settlement. However, on the 5th of December, we've received his biometric residence statement, which states only that he's got leave to remain. Can you please confirm over the page our client has been granted indefinite leave to remain? That then leads to a response 11 days later. It's above that, on the 22nd of December, thank you for alerting us to this error. I've attached the correct decision letter. Don't need to go through the rest of the correspondence because it's then about whether that was the proper thing to do or not. But you then get the correct decision letter, which again you've seen this morning, but just for your record, again, that's at page 229. And if you turn to that, you'll see under what this means for you, that's the passage that's been changed. You've been granted permission to stay until the 12th of May 2026. You can apply to extend before the current permission ends. And you've got that whether or not you appeal against the refusal of the protection claim. And again, the passage on the reasons for family and private life is identical at page 234. So I promised a moment ago in response to my Lord Senior President that I would take you to the rules, which might explain the reason for the difference between 20 years. Can I do that now? You'll find them in tab, in the first volume of authority behind tab 14. And this is Appendix Private Life.
If you can give the page number each time.
I'm so sorry, 223 more.
Thank you. That's
And perhaps it's worth going through this in a little detail. You'll see the private life route for a person seeking permission to stay in the UK on the basis they've developed a private life in the UK. If you look at the third in the paragraph down, the private life route is a route to settlement. So this is what he was applying under, and it was a route to settlement. So it's expressly not dealing with settlement. And you'll see alternative routes may be available to those considering the private life route. For example, a person may be able to qualify for immediate settlement on the basis of 10 years long residence. In the paragraphs 276A to D of these rules. They are completely different rules, which have troubled this court on many occasions in the past, in cases like Tulsa-Mackay and other cases about the earlier emanations of those rules. But then you'll see the validity requirements, first of all, PL1, a person applying for permission to stay on the private life route must apply online on the website on a specified form. Now, normally, that's a very important requirement, but that then gets disapplied by PL 1.3. If a private life claim is made under Article 8 and it's made A at the same time as a protection claim or further submission in person, then if you look down at C, it's not terribly clear, but in the second line of C after the comma, the requirements of PL 1.1 and PL 1.2 A and C will be waived. So there was a waiver here for him applying under these provisions for a limited period of private life. That's relevant because the same waiver in terms of using the official forms and also in terms of paying fees and so on and so forth doesn't apply for settlement. And over the page, you've got the suitability requirements. I don't need to trouble you with that. But then the substantive provision, by the second hole punch, you'll see residence requirements for an adult on the route, including a young adult, PL 5.1, where the applicant is age over 18 or over. A, the applicant must have been continuously resident in the UK for more than 20 years, or B, where the applicant has not been continuously resident for more than 20 years. The decision maker must be satisfied there will be very significant obstacles to the applicant's integration in the country where they would have to live if required to leave the UK. So I took you to the passages in the decision which refer to the obstacles to integration. So he's falling within 5.1b, although there's not an express statement that he hasn't made his 20 years. Effectively, that's the analysis that's been carried out. So he succeeded under 5.1b because the obstacles to integration, significant obstacles, were accepted. Then, over the page, at the bottom of page 225, 9.1, you're satisfied that all the suitability requirements and eligibility requirements are met, then unless the suitability exception applies, the applicant will be granted permission to stay on the private life route unless otherwise the application will be refused. Again, it's all about being on the route. And then period is over the page at 226, and you'll see 10.1 is under 18-year-olds, 10.2 is young adults, and then 10.3, which is this individual. In all other cases, the applicant will be granted 30 months permission to stay. So that's where you get the mandatory grant of 30 months. It talks about being on a route. The route is to settlement, which is then dealt with in paragraph 11, again on the facing page, validity requirements for settlement on the private line route. And you'll see that you have to apply 11.1 on a specified form, and 11.2 various requirements. 11.3 must have or have last been granted permission on the private life route unless they're a child born in the UK. And then for an application which doesn't meet all the validity requirements is invalid and may be rejected and not considered. So what you don't get is the waiver for using the official form because settlement in ILR is such a valuable right. So you have to go through the route to get there. And again, I entirely understand my Lord's question to me about is it realistic that he's going to go anywhere here. But the rules and therefore the public interest do identify a particular imperative to be given to people being here for particular periods of time for reasons which are well rehearsed in the cases and elsewhere before they apply for settlement. Things can change. So that's the short background to the rules that I wanted to go through here. And as I say, the reason why I wanted to take you in my submissions in this order was to show you how the decision making proceeded on the basis of what the decision maker was being asked to do and asked for, and then the rule framework within which that request, so far as it concerned private life, fell to be considered. And that's obviously consistent then with the revised decision that's later made. I'm not proposing to go through the statutory framework in any detail. I've got an eye on the clock and I need to go to the cases for you. And there is very little really between us on the statutory framework. Really what's between us is about the consequences. So for example, section 76, but perhaps I can just go to just the core provisions in the Act about granting and refusing leave because that obviously is what so much turns on in this case. But as for the rest, I'll take it as read, and I'll give you some references to Asylum. Can I take you to the 1971 Act behind tab 1, and I'll take you just to two provisions here, essentially to make good the background to my submission on incidental powers. The first is section 3. So you've seen this already, but just to recap, general provision for regulation and control, sub 1, except as otherwise provided, where a person is not British citizen, A, he shall not enter unless given leave to do so. B, he may be given leave to enter, or when already here, leave to remain, either for a limited or for an indefinite period. So that is your, if you like, requirement to have permission to be here, and it has to be one of those two species, either indefinite or limited leave. I know these provisions are incredibly familiar to this particular clause. Then you have, of course, over the page 2, the provision on the rules, which are laid down as to the practice to be followed in the administration of this Act for regulating the entry into and stay of persons into the United Kingdom of persons required to have leave to enter, and so on and so forth.
Sorry, where are you reading from?
I'm sorry, subsection 2 at the bottom of page 22.
Thank you.
My apologies. Now, the reason I go to this is that my submission ultimately is going to be that the incidental power falls to be implied because it gives effect to the proper application of both section 131B, so the giving of leave to remain, 3.2, which is the primacy given to the rules as the framework for the administration of the Act being laid before Parliament. They are expected to be respected and leave to be granted in accordance with them. And then, as I'll come to in just a moment, section 4, the mechanism for granting. But just a headline while I'm in section 3, that's why I'm coming here. So Parliament expects people to be given leave to remain where they qualify for it and not where they don't. The framework for qualification is the framework of the rules, which is given the primacy it has because it's laid before Parliament. And therefore there is an enhanced duty to try and ensure, or to ensure, not just try, but to ensure that decisions are made in compliance with the rules, and where they're not, in my submission, that is a supportive factor for the implication of an incidental power to reissue decisions, to withdraw and reissue decisions. Now, can I go on to section 4? That's the administration of control at page 36. And again, this is the provision that requires the power to give or refuse leave, the power to give leave to remain or vary any leave, to be exercised by the Secretary of State and to be exercised by notice in writing given to the person affected. That is the mechanism by which the leave is granted. Now that, against me, means that the initial letter was if you like, a valid on its face grant of indefinite leave to remain. I'll come to this in just a moment.
Down, please.
I'm so sorry,
Note
Melody.
of that. So
I'm sorry.
letter 1.
On its face, it appeared to be a valid grant of leave to remain.
Thank you.
Indefinite leave to remain. And that's effectively because of the effect of section 4.1 and how that's been interpreted in the case law. Again, I'm not seeking to depart, and nor could I, from that case law, so I'm not going to go through all of that. But what again it means is there is a primacy given to the notification process, and the notification process being used to notify the correct decision. Where the decision is wrong in my submission, there is an incidental power which enables you to withdraw and reissue. And of course, one of the points made an argument this morning by my lord was, well, actually this happens quite frequently, but usually the other way around, where the Secretary of State is withdrawing decisions and somebody is quite pleased about that because they are then getting a decision which is in their favour. It might not always be the case, but it routinely happens in litigation, in the tribunal and in the courts. The Secretary of State will withdraw decisions that have been granted refusing leave and either reissue a decision granting leave, or on some occasions grants a different decision, still refusing leave. There may be occasions where the Secretary of State withdraws one decision, but makes a new decision which actually grants a better form of leave. That is possible. It could be that the wrong decision has been made in too harsh a manner, or it may be that the Secretary of State accepts that there is unlawfulness in the decision. In all of those cases, there is a withdrawal of the decision and a reissuing without any new application having to be made. In my submission, that recognises the public interest in there being a rapid and let's say convenient, not convenient in the way that's deprecated in the case law, but convenient in the sense of convenient to everybody way to ensure that the right decisions are made and can be relied on where a mistake has previously been made. And usually that is seen as being somebody's advantage.
Is there any other express power by which a refusal of asylum can be set aside by the Secretary of State?
In that sort of scenario?
Yeah.
No. We've thought about this over lunch. We can't identify a specific power in that situation. So in our submission, it has to be through effectively an implied power in sections 3 and 4. Now, the cases are often slightly vague about precisely which statutory provision gives rise to the implication. Sometimes it's clear from context because you're only arguing about one provision. Sometimes it may not matter because you have something like what my lady identified, an equivalent to section 111 of the Local Government Act, or there may be other reasons. On this occasion, we say it's properly to be implied into the scheme created by sections 3 and 4 read together.
What do you say about Mr. Mackenzie's point that those are actually where they're adverse decisions and there's a difference when it's a beneficial decision being removed?
We say there's absolutely no basis for that distinction whatsoever. The effect is still the same. So if you have an adverse decision which is removed and a beneficial decision which is granted, you still have a withdrawal and effectively a regrant of what's said to be the correct decision. In both cases, you have, for what might be a variety of reasons, an incorrect decision first time round. It might be because it's unlawful. It might be because there's been a mistake. But either way, you have a new decision being made and no other power by which that's being done. In our submission, there is no proper distinction to be drawn. It's not a one-way street in that sense.
You just said in both cases you have a withdrawal and a regrant. You don't. In the first case, you have a refusal and either a decision to grant leave or a decision to reconsider. And in this kind of case, you have an initial grant and then that's taken away.
But you have my lady's quite right. You have a withdrawal and remaking, effectively. So you have a decision maker who is either going to be saying, like in this case, well, I made that decision. That was actually wrong. It was notified, so it was effective in that sense, but it was wrong because I hit the wrong button, whatever the mistake may be. Therefore, I'm going to withdraw that and I'm going to make the correct decision, which is this one. In the situation, on the premise that my Lord put to me, you have a situation where you have a negative decision. So you have an exercise of the power. Under section 3, you have effectively leave refused. You're being asked to grant under section 3. You say, no, I'm going to refuse. And then you withdraw the decision and say, okay, I'll grant. So either way, you're within the same part of the statutory scheme, exercising the same functions for the same purposes, but coming to either the opposite conclusion or at least a materially different conclusion. And you may have, as I say, a third scenario where perhaps the Secretary of State grants one form of leave, and that might carry particular rights with it, but realises either of her own motion or because it's put to her that she should have granted a different form of leave which has an enhanced set of rights. And on the same analysis, because she has an implied power to revisit that decision and on the basis of actually getting it right, she can do that. And that is an approach, an analysis, and this is one of the touchstones in the case law I'll come to in a moment, a case called Chowdhury. One of the analyses is that promotes good administration. Now, I entirely accept that I'm sure the point will be put to me, and it's already been put in argument generally, that good administration would be promoted by making the right decision in the first place.
Exactly.
Of course. Again, I hope I've made it clear I accept that. But with the best will in the world, it's not just the immigration sphere where mistakes are made. Unfortunately, mistakes are made because human beings operate the system.
The argument the other way is that if you're right, it promotes bad administration because there are no bad consequences to not getting it right first time.
Well, my lady, in my submission, that's not the correct way to analyse it. First of all, the significance of the statutory scheme is in getting decisions right. Sorry, I say that respectfully, of course. The significance is to get decisions right. And that's because decisions have a consequence for the public interest. Now, there's a variety of ways in which getting a decision wrong may have a disbenefit to the public interest. And of course, it will be said, that's the Secretary of State's fault, get it right. But if the decision is wrong, it has to be corrected, if possible, if it's possible to do that. And ultimately, it's not going to promote bad administration by the Secretary of State being able to say, well, actually, I accept now that was the wrong decision. I'm going to withdraw it and remake the right decision, because that is then ensuring the powers Parliament conferred are operated in the correct way. And likewise, one of the points made in argument by my learned friend this morning as well, there's a lot made, for example, of the prospect of giving a criminal leave by accident. Well, you can just make a deportation order under Section 5. Well, that's correct. But of course, in the meantime, you have a process, quite a laborious and onerous process that has to be gone through in doing that. I'm going to show you a case in a moment where the relative efficacy of different routes is a factor that can be taken into account in implied powers. But you have a process that has to be gone through. You, in the meantime, may be paying benefits to the individual concerned. There may be a very real impact on the public purse for somebody who never should have had that leave. And it is highly in the public interest, in my submission, to be able to correct that leave quickly and efficiently where there is a mistake that's been made. It doesn't, of course, exonerate the Secretary of State from the erroneous process of decision-making which she has engaged in. Again, no part of my submissions is intended to suggest that it does. But it's not the Secretary of State, ultimately, who stands to lose out. It's the public interest. And that's why it's sufficient to have a benefit.
Sorry,
No,
can I just, you talked about withdrawing a decision and perhaps making a more beneficial one to the asylum seeker, you withdrawing a decision and making a more negative one. Very often the Secretary of State withdraws the decision and says, I'm going to make another decision. Sometimes they follow quickly, sometimes they don't. We've all seen that. Is the same power for that type of decision making, withdrawing and then saying I'll make a different one, still sections 3 and 4 according to your submission?
Yes, it must be. There's no alternative power that says where you are, for example, involved in litigation and you want to concede the litigation or you want to take some step in the litigation, you need to do a separate thing. And there's been none suggested, as I understand it, from the other side. We say it must be an exercise incidentally of the powers in Section 3 or 4, which is beneficial on many occasions to the private individual, but overall beneficial to the public interest, because the public interest is in getting the right decision made. And to give an example, for example, traditionally, family reunification rights for refugees have been at a very enhanced level. It's usually the easiest form of family reunification to exercise. Other forms of leave might have much more limited forms of family reunification. So you could have a situation where somebody is granted a more limited form of leave, the Secretary of State reconsiders and says, well, actually, I accept they're a refugee, and they therefore get a form of leave. So they've still got leave, which has enhanced benefits. It's not quite as black and white as my learned friend puts it, with respect.
Thank you.
Grateful, Mona. So I think I've taken you to provisions I needed to go to in the Act. Against that background, can I come then to my submissions? I've taken you to my introduction, taken you to my facts, taken you to the rules, now it's submissions. Now, I was going to say before yesterday that logically the first question is whether there's an incidental power to withdraw the grant of ILR in a case like this. But I want to answer first of all the court's question sent to us by email yesterday about whether in fact the original grant was lawful. My learned friend has put it fairly and correctly. We had an exchange about this yesterday. To be clear, as I think he's indicated, it was raised, the legality of the grant, in the summary grounds of defence. Can I just show that to you?
Yeah, it was raised in the summary grounds of defence. It was also raised in the Office Tribunal's decision after the oral renewal hearing. So the Secretary of State had an opportunity to rely on this point and decided for whatever reason not to.
That's absolutely right. And the way it was, it's perhaps worth just looking at how it was being put at the relevant time, and I'm not seeking to revive it at all in the way that it was put there. The summary grounds deal with it, well, really beginning at page 149
Of the bundle. Yeah.
of the bundle. Yes, I'm sorry.
No, that's fine. Thanks.
It's behind tab 16 if you have tabs. Different counsel at this stage. You'll see at page 149, paragraph 22, the text of the letter was incorrect. Decision maker did not subjectively intend to grant ILR, erred in public law terms in doing so because their decision, as it was put here, was not Wednesday reasonable in light of their error, did not consider the applicant satisfied the requirements for a grant of ILR, or perhaps did not consider those requirements at all, otherwise acted unreasonably by inadvertently using the incorrect wording template for a grant of ILR. Then that's picked up as public law error as an alternative argument at paragraph 24. Alternatively, and if required, tribunal invited to hold, decision was vitiated by the decision of the 13th of November was vitiated by public law error for the reasons given, and issue appropriate relief, recognising this declaration, and if necessary, a quashing order. If it does so, then the 13th of November decision has no effect, and then there are submissions made on the exercise of the powers in section 31 of the Senior Courts Act. Now that is what led to the permission order after a hearing before Judges Canavan and Hoffman at page 175 behind tab 21. And you'll see at an early stage in paragraph 3 of the reasons.
Sorry, can you give the page reference again?
I'm so sorry, yes, 175, my lord.
Thank you.
Paragraph 3, 3 lines in, the applicant does not dispute that he was not entitled to ILR under the rules, nor does he dispute that the grant of ILR was made to him in error. So the facts were fairly clear from an early stage. Over the page, paragraph 4, carefully considered the pleadings and submissions, satisfied that the case is arguable, no power to revoke outside section 76. And then this, finally, we also had submissions regarding whether the respondent can seek an order quashing her own decision to grant ILR. We doubt whether it's procedurally possible in this case. Several reasons. Judicial review claim brought by the applicant against the decision to grant limited leave to remain, not the decision to grant ILR. So it's not the decision under challenge. Respondent has not filed a separate application for JR to seek a remedy in relation to the ILR decision, which would have been out of time. And the argument does not relate to substantive legal issue but goes to remedy. But we don't seek to tie the hands of the respondent when it comes to arguing the appropriate remedy before the judge at the substantive hearing. Nevertheless, careful consideration should be given to the respondent as to how much court time should be devoted to its argument. Now, I don't seek to go behind any of that. It's quite right that this, to say that following that order from the tribunal, the point was not taken any further by the Secretary of State. That is absolutely right. And indeed, given the observations in paragraph 5, perhaps unsurprising, it is right of the tribunal to say that actually the Secretary of State's point was directed at a different decision. And what the Secretary of State was asking for was a very different form of relief. In other words, the quashing of her own decision. I'm going to show you a decision in a moment where some public authorities can and do apply to have their own decisions quashed, but it's a very particular procedure and not one that could be used here. But either way, we are not seeking to revive the argument in that form. What we say is this. The original decision letter, grant of ILR, was unlawful because the appellant did not meet the relevant criteria. That is a statement of legal fact. And there was no other basis on which to grant it, and that wasn't the intention. And that's so, obviously, even though he could in principle have been granted leave outside the rules, because he has never suggested he met those criteria either. But what we don't do is to go as far as to say, in effect, that this was a completely ultra vires decision, precisely because, in theory, there could have been a grant outside the rules. So the position is that the grant on its face was ostensibly lawful, and if the Secretary of State, without doing anything more, had tried to deny the validity of the grant, then YC would have been entitled, in part on the basis of ex parte rem, but also on the basis of high case law like Hoffman-La Roche and Madeira to say, no, this decision is valid and it's valid unless and until quashed or set aside or withdrawn. So, having not pursued the points about quashing following the refusal effectively at permission stage, the Secretary of State is not seeking to revive that at all now. But what we do say is that you can and should take into account the legal circumstances and legal status and characteristics of the decision, i.e. that it was not a lawful decision in the sense that it was not granted according to the rules and was clearly the incorrect application of the intention of the decision maker when you are considering whether or not the particular implied incidental power, if it exists, can be exercised here. That's a relevant factor for those purposes. But what I don't do is seek to revive the way it was put below. It's far too late to do that, and I wouldn't seek to do it in any event. Now, against that background, I was going to take you to Madeira, but I'm not going to. I don't think there's any dispute between the parties about that. Can I take you, though, to...
Sorry, you were going to take us to...
sorry, the case of Madeira?
Yeah, so, sorry.
My Lord, I'm sure you'll be familiar with it. The Supreme Court case about effectively the principle that validity is, or invalidity is relative.
Yeah.
No void ab initio categories and all that kind of thing. Can I, though, take my lady and my lords to another case that may just be worth looking at for context here and by analogy, which is the case of Oxby, Crown and Basildon District Council in Oxby.
Yeah.
Can I just hand these up to the court?
They didn't get in the bundle.
I'm sorry, this is an addition. I'm very sorry.
Don't worry, we referred you all to other cases.
He includes Madeira, actually.
So yes, I'm not going to trouble you with Madeira because that's in here as well.
Mr. Mackenzie's got a copy, have you?
Yes.
It was emailed to us, wasn't
Sorry, can you just remind me which tab Madeira is that, please?
Madeira is not in the bundle,
It's
so
on
if
the
I was going
bundle. No,
we have copies if my lady would like it. We can hand it up.
Oh, yes, please.
Yes, I'm so sorry. I spoke too soon.
No, I'm the nerd's nerd, so yes, please.
And perhaps just for my ladies and my lords' notes, the relevant passage in Madeira is at paragraph 27 onwards in the judgment of Lord Reed. And essentially he says there's no hard categories of invalidity, validity and invalidity and nuance. And reiterates the old Hoffman-La Roche principle of presumed validity. And the case of Oxby is a planning case, and essentially it's a case which demonstrates that certain public authorities, planning authorities being perhaps a prime example of it, do occasionally judicial review themselves for cases of fundamental error or similar things. So occasionally a planning permission will be granted by mistake by the planning authority. And what happens often is that the planning authority will put up the head of the planning committee, so an elected member who has responsibilities in the planning field, to act as a claimant, usually with an indemnity from the local authority against costs and such like, and they will bring a judicial review claim to quash the decision. Now, the reason I'm taking you to this is it's an interesting examination of the power to deal with mistakes and errors, where there is in fact a parliamentarily designated statutory route for doing so. So there is a revocation power which carries a right of compensation in planning cases. And nonetheless, the courts have recognised the ability to use an alternative route. Now, I'm not suggesting here that the Secretary of State would judicially review herself. Obviously, that wouldn't occur. It's particularly suitable for a local authority which has committees, and it's recognised in the cases. But what matters is the alternative route. So you'll see from the head note that the appellant was the leader of Basildon District Council and directed to bring judicial review proceedings to quash an unlawful decision to grant planning permission. And the reason was that there'd been an independent inquiry into the performance of the council planning functions, which had concluded that certain councillors had not disclosed an interest and the planning system had been manipulated. So the inquiry had recommended that various planning permissions should be revoked under section 97. So that's the revocation power. This would have entitled the recipients, the beneficiaries of the permission, to substantial compensation, because this was about development of land. They, as third parties, took three preliminary points. First of all, they took a locus standi point. Secondly, an alternative remedy point. And thirdly, a point about undue delay. That's irrelevant for present purposes. If I can take the court, please, to conclusions, the findings, you'll see at page 292. Page 292 is the analysis on sufficient interest. You'll see at letter D, the peculiarity of the present case is that the applicant, Mr. Oxby, is in effect acting as a representative of the respondent on the direction of the counsel that he seeks to, that he's bringing the proceedings, and it's the decision of the counsel which Mr. Oxby seeks to have declared void. It's possible to justify the making of the application by him as an elector and council taxpayer in the context of local government, such a basis for establishing sufficient interest has been recognised by Mr. Justice Popplewell in the judgment, but that's a separate judgment, conveniently citing from Lord Justice Lewis's book on judicial remedies. Such justification would be artificial in the present case. More germane is what was said by Mr. Justice Nolan, ex parte Jones. The present case concerning allegedly unlawful conduct by a local authority. Council granted a council house to a councillor. The applicant was another councillor. No objection was taken to him appearing on the record. You will see there, citation, if the application was made by the leader, the view being correctly taken by the council itself could hardly be both applicant and respondent. Council Mrs. Kingdown again accepts correctly that the leader had necessary locus. So don't need to go through any more of the detail, but that's just to explain how this sort of proceeding occurred. And it does happen, I don't say relatively regularly, but it happens from time to time in the planning judicial review sphere.
Mr. Mackenzie would no doubt point out that what they didn't do was just withdraw the decision.
No, that is right. But what this does show you is, and this is the reason I'm going to, is that the alternative, that there was a statutory alternative available, which was far more beneficial to the disappointed party. In other words, it gave them substantial compensation. But the conclusion under alternative remedies is that nonetheless, the local authority could take the view that it was more appropriate and expedient, and that's a statutory test, to bring the judicial review proceedings and avoid the compensation. So true it is, it wasn't about implied powers, and I'm not suggesting it was, but this is to deal in part with the argument about section 76, which is that, well, there is an alternative statutory process, and that's the one you should use, and if you don't meet the criteria, don't do it. Now, on alternative remedies, you'll see that dealt with on page 293.
Sorry, can we just pause there for a minute?
Of course.
The main difference between this case and the argument you're putting forward on behalf of the Secretary of State is that, firstly, as my lord pointed out, the local planning authority did not purport to withdraw its decision. But number two, it applied for JR and went to the court. There's nothing equivalent here. The Secretary of State hasn't gone to the court and said, oh, my decision's unlawful, please quash it. This is all internal decision-making by the Secretary of State in circumstances where Parliament has said there's an express power to revoke.
Well, Lady, that's right, and I'm not suggesting, indeed I'm suggesting absolutely the Secretary of State can't come to the court and have that done, but the reason I go to this case is that it shows you the fact that there is an alternative procedure which Parliament has designated to be used, and indeed which is highly beneficial for a beneficiary of the wrong permission. In other words, they get compensation if you take it away. Did not stop the public authority in question from using an alternative mechanism in effect to take down the permission.
It's not my point, it's not an internal mechanism. The local planning authority didn't say, oh, we've got a power to revoke, but that would involve us paying compensation, we're just going to withdraw it. They went along and applied for judicial review, so they got the court to quash the decision.
My lady, I entirely accept that, and that may be more appropriate in the planning sphere, but the point is, it shows that the existence of the statutory mechanism is not the absolute answer that it's posited to be in this case. That's the reason I'm going to this. So it could have been, and indeed there is an argument along these lines, that the existence of the Section 97 power to revoke was the answer. And it was there. It covered absolutely the territory, but it meant you had to pay compensation. That was going to cost the council a lot of money. And so the council could decide that it was not expedient in the statutory language to adopt that mechanism. Now here, I say we're a fortiori. True it is, we're using an internal process of the Secretary of State, and either you're going to find that there is an incidental power or you're not. And if you don't, so be it. I can't succeed then on this case. What I'm saying is the existence, and this is a very powerful point that my learned friend relies on, or a very strong point in his submissions, the existence of Section 76 means there's nothing else that can be done. Parliament has spoken, and it hasn't spoken to give you this power. But in this case, Parliament had spoken to give precisely that power with a financial compensatory consequence, and the council avoided it.
Yeah, pipeline for anyway. I will go round and round in circles.
My lady, I completely accept, of course, we haven't come to the court. And the reason I took you, although it's not a passage I can rely on in my favour in this case, but to be candid and clear and to show you the passages on locus standi, was to show you that that's a process that's convenient and worse for local authorities where they're able to select an individual who is, if you like, acting against the authority but is part of the authority, the leader of the council. That doesn't work in the context of the Secretary of State. But there are other mechanisms that are available. The point is a statutory route is not the answer. So on alternative remedies at letter F on 293, you'll see the statutory scheme provided for in sections 97 and following is a mirror image of the provisions governing the grant. So again, it's part of the same processing scheme. The initiative is taken either by the council or by the Secretary of State. So in fact, there were two powers. The Secretary of State could intervene in these cases too. Notice of revocation has to be served in that way. Any person has the right then to state that they oppose revocation, and effectively you go to an inquiry. Important features of the power of revocation that may take into account circumstances and on the page arising since the original grant. The power is granted in terms which are widely expressed, exists wherever it appears to the local planning authority it's expedient to revoke or modify any permission to develop land. So I use the term expedient before. That is effectively the statutory test. And you'll see at the next paragraph, in the present case, valid grounds for revoking relevant consents. On planning grounds, more tenable view that consents ought never to have been granted. Well, that's rather like this case. Indeed, it's the case of the applicant, that they manifestly should not have been granted. Therefore, in this case, there was and is scope for the council to exercise the power to revoke under Section 97. So they were squarely within the statutory framework that Parliament had designated. Again, a lot said in this case about what Parliament has done, and indeed what Parliament hasn't done. There are a lot of submissions made on the basis of parliamentary silence. But they may and should only do so if they consider it expedient to exercise the power. The exercise of the power carries with it a right to a person interested in the land to apply for compensation under Section 107. As previously stated, it's the assumption made by both the Council and the Howcrofts that such compensation would, in this case, be substantial. The Council does not consider it expedient to revoke the consents. To review of the Council, its contention, they were vitiated by either actual or apparent bias, should be declared void without the payment of compensation. And they say it would be wrong in a dereliction of duty not to seek to have them set aside, but to choose to revoke them and pay compensation. One might ask, well, why? Parliament's given you the power to revoke and pay compensation. Why is that such a bad thing to do? Obviously, because it's going to cost you. In my judgment, this is a legitimate and proper attitude for the council to adopt. If they're entitled to have the consent set aside without the payment of compensation, that is what should occur. And they should not lend themselves to the payment of inappropriate and unnecessary compensation by reason of exercising their power under Section 97. My submission, and this is a very well-established case and principle in this field, but the idea that the payment of compensation might be inappropriate and unnecessary, where Parliament has said, if you want to revoke a planning permission, you may do so, but it will cost you, it is somewhat surprising.
Well, it's the use of the wide word expedient. And
Well,
the fact that
yes.
the assessment of what's expedient is a matter for the councils.
But that is right. But of course, given that Parliament has designated a right to compensation, that issue is going to arise in every case. You're always looking at compensation when you're revoking a planning permission.
Well, so the approach of the Court of Appeal in this case was, there it is. If your consents are vitiated by actual or apparent bias,
You can do it.
it's open to the council to apply for judicial review of the consents and get them quashed.
Yeah. The grounds here are actual or apparent bias, but it's frequently applied across the range of public legal grounds. You can see the further analysis in the paragraph which follows at letter F. Don't seek to go through all of that, but you can see what it says there. So the reason I go to that is, again, just to, at the start, frame the analysis in the case. Yes, Parliament, I'll be coming back to this in due course, but yes, Parliament has spoken to a degree with Section 76, and it hasn't included a power of this nature. When it's done so, that in my submission is not the whole answer, though. The courts have recognised circumstances where, notwithstanding the existence of a parliamentary route, a statutory route carrying benefits to individuals of withdrawing decisions, you may nonetheless take a different route, which is more convenient and expedient. And true, the expediency test is set by Parliament.
But the reason Section 97 was relevant was that this was an application for judicial review, and the argument the other way was, well, there is an alternative remedy for the council. They don't need to apply for judicial review. They can just revoke under Section 97. So the point was being used for a different purpose than perhaps the reason you're deploying it.
Well, my lady, I accept that. Of course, this arose in the context of a judicial review in which it was being said, no, you can't do this. As a matter of judicial discretion, permission effectively should be refused because there's an alternative for you. But in my submission, the point holds good. It's not a complete barrier to alternative methods of dealing with administrative mistake. That's where the proposition goes. So I just want to deal with Oxby at that stage to set that out there. The other case that I was proposing to deal with, but I will deal with just very briefly. My learned friend, I don't think has said anything about this morning, but we were asked to consider the case of Vassar, the decision of Lord Justice Lewis that the court indicated yesterday. That was a decision that was considered by the upper tribunal at paragraph 26. My short submission is that the analysis in Vassar does not take matters any further. It was a quite different decision about Article 10.2 of the withdrawal agreement and whether or not the granting effectively permission to enter amounted to a facilitation of entry for the purposes of the agreement. It gave rise to very particular issues in under the withdrawal agreement, which aren't replicated here. And given nothing else has been said about it by my learned friend, I wasn't proposing to say anything about it.
Yes, I mean, well, Justice Lewis did have some observations to make about the argument that an apparently valid grant of the right to enter at the border, you can't just go, oh, I didn't do it.
Well,
so you did have something to say about that.
That is right. I mean, my lady, I can deal with it now.
It's a matter for you. If you want to deal with what you have to say, do so. If you don't think
Yes. Well, my lady, as my lady's raised it, why don't I deal with it then in that case? I wasn't doing it because it hasn't been dealt with this morning, but my lady's raised a point, so I'll deal with it. And can I check if the court has a copy of Vassar as it was notified to us? If not, we have copies here we can hand up.
That'd be very helpful, thank you.
Let me do that.
I think I have got a copy. Thank you. Go on, thank you very much.
You'll see, the court will see from the head note, it was a case about an African Albanian national who presented at the UK border before the end of the transition period, who wanted to be allowed to enter and reside in the UK with a sibling who was a national of an EU member state. He had his passport stamped with the words admitted under the EEA regulations 2016, and he entered. He then applied for pre-settle statement under the US, and that application was refused on the grounds that he hadn't produced a family permanent residence card issued. There was then an appeal, and the Secretary of State further appealed. In fact, there were two appeals that were dealt with. And the issue you'll see at letter F was an argument that the admission pursuant to the stamps in the passports amounted to residence being facilitated in the UK within the meaning of Article 10.2 of the withdrawal agreement, and therefore refusal to grant pre-settled status was a breach of the rights under Article 18. That was the background to the case. Lord Justice Lewis's observations begin at paragraph Well, the analysis begins at paragraph 57 on page 58.
I mean, the critical bit is paragraph 6, what he says in paragraph 68, I think.
Yes. Yes, exactly. And what he's quoting there is effectively what's now usually advances the Margira point of the Hoffman-Roche. It comes from Smith and East Ella, but it's a presumption of validity.
Yeah.
And the point that he makes, which we entirely accept, is that those decisions not having been challenged or postulate declared unlawful, they are valid. Now, I entirely accept that is right, and of course, in a sense, that's the analysis that lies beneath the ex parte Ram decision. That's why I said this morning that certainly until the decision was withdrawn, YC was entitled to rely on what on its face was an apparently valid grant against all the world, including the Secretary of State. So in ex parte Ram, you have somebody who comes back with a grant which has never been disturbed, albeit was granted incorrectly, and the Secretary of State tries to say, well, the grant was wrong and therefore I'm detaining you. He brings habeas proceedings and says, well, you can't detain me because I've got this grant, but nothing was ever done to remove the grant. This case is logically prior both to Vassar and ex parte Ram because there has been a withdrawal. Now, if there isn't a power to withdraw, then there isn't a power to withdraw. The point put against me, based on ex parte Ram, is that, well, if there is a power to withdraw, that would have been an answer to ex parte Ram and other cases. But only if the power was used. It's often the case that a decision maker has attempted to say, well, this particular decision is unlawful and therefore you shouldn't follow it, you shouldn't do anything based on it. But the prior question is, are you trying to do something about it? Are you trying to withdraw it, or has it been quashed? In my submission, this is an area where there is an implied power to withdraw. If there's an implied power to withdraw, then once it's been withdrawn, one is outside the scope of ex parte Ram. It's just an issue that wasn't argued and wasn't advanced in ex parte Ram. Or the other cases.
Is there any temporal limit on the implied power to withdraw?
Well, not an express temporal limit, but as you'll have seen from our skeleton argument, and indeed from the Upper Tribunal's ruling, one of the points made in the Chowdhury case is that the usual judicial review principles of, for example, administrative fairness and so on would apply. This is a case, present case, where the error was noticed extremely quickly. Again, credit to the appellant solicitors for that. They're the ones who noticed it. But it was dealt with very quickly. He didn't rely on it in any way detrimentally. In many cases, that might not be true. And it might be that somebody has relied on a decision and acted to their detriment for a long time. If that is the case, then they will be able to challenge any attempt to withdraw it as being unlawful in public law terms. We fully accept that. It is the usual public law controls. And that is what some of the cases I'm about to show you actually say.
Thank you.
So that's all I wanted to say about Vassar. So, is there then an incidental power of withdrawal here? We say there is. It's incidental to the powers in sections 3 and 4. Can I take the analysis in 3 stages? First of all, the general public law cases on incidental powers. Secondly, the immigration cases on incidental powers. And thirdly, what I'm going to term the other irrelevant immigration cases. The general public law cases, we say, demonstrate that public law does recognise in principle, and of course, subject to the right statutory context, an incidental power in particular situations to withdraw administrative decisions. And although the cases have focused on fundamental error, in slightly different ways sometimes, and not specifically on administrative error or clerical error, we say there is no true distinction between the positions. The first case I wanted to take you to was Porteous. That's in behind tab 23 at page 370. Porteous is a homelessness and housing case. You'll see a decision of the Court of this Court, Lord Justice Mantle and Sir William Aldous. The facts you'll see in the somewhat lengthy head note, which goes on for 3 pages, at page 371. And essentially, the position is that a local authority tenant left a council property thinking that her tenancy had been transferred to her sister. in fact, it hadn't been transferred. She then came back to another local authority area, was provided with homelessness accommodation. So the second local authority made a positive decision in her favour. It then came to light that her previous tenancy hadn't transferred. She therefore had available to her alternative accommodation, and the new local authority withdrew their decision. So effectively they'd acted on the basis of fundamental error of fact. You'll get that from H10 through to H12 effectively. If I can then ask the court to turn over the page 374. There's an initial appeal against that decision in the county cause, saying that the local authority in question, the second local authority which had granted the accommodation, had no power to reopen its decision. And you'll see it on page 374 at paragraph 5, Roman 1. The learned judge erred, this is the ground of appeal, in holding that the respondents, having determined that they owed a duty to the appellant, were entitled to decide subsequently that they did not, in fact, owe such a duty. Ground 2 was about the fact that whether the respondents were entitled to come to a fresh decision, and the allegation was that the judge had erred in law in holding that the appellant had a duty to provide them with information. So there was an issue about how much the appellant had to say. And then at 6, you'll see grounds 1 and 2 are closely related. You'll see the way the argument is put there. And over the page, on page 376, on the other side, Mr. Arden, QC, submits the local authority's entitlement to reach a new decision is not limited to cases of fraud. So there have been some earlier case law suggesting that you could withdraw a decision in a case of fraud. He said that authority may reach a new decision where they discover that a relevant factual element in their decision was simply wrong, whether caused by fraud, non-disclosure, or simple oversight. And there's a reference then to the case of Crawley and B on a judgment of Lord Justice Buxton. Just in that cited passage, you'll see towards the end of the page, 5 lines up. Second, it means that even in quite unforeseeable circumstances, material as to intentionality comes to local authority's attention after the original decision, whether or not that decision relied on intentionality. The authority cannot take it into account, so the applicant may obtain accommodation, a valuable public resource, when in truth he's not entitled to it. And then he says the application of jurisprudence in public law to the process of decision-making in homelessness cases doesn't therefore necessarily lead to the conclusion the decision once taken cannot be revisited. And he departs from an early decision, Cerebral Cooper. The overall test applied there in the B case is whether the whole circumstances such as to justify any and if so, what relief in public law. And then this analysis from Lord Justice Manful. Although other authorities have been cited and the arguments refined, it seems to me the question raised is a straightforward one. Is the local housing authority entitled to revisit and change an earlier decision if the earlier decision resulted from a fundamental mistake of fact? It would seem surprising if it could not. If an exception may be made for fraud, why not for fundamental mistake? After all, the resulting harm may be no greater in the one case than the other. Here, without there being any suggestion of bad faith on either side, unknown to either party, there was accommodation available at the date of the original decision. Once the true position became known, why in common sense and justice should the local authority be held to a duty to provide accommodation which the applicant does not need and which could have been made available in another more deserving case? And then there's a debate about material non-disclosure. And then 5 lines up from the end of the paragraph. Accordingly, while I recognise there may well be a distinction to be made between circumstances prevailing at the time of the decision and changes occurring thereafter, and the implication must be there that it's more difficult to imply the power if it's a change of circumstance case, I would hold that the judge was right to find the local authority being entitled to revisit and rescind its first decision, so a different word being used, but for the same substantive action. Well, we say that is important in understanding the rationale for an incidental power in a case like this. Of course, it's not an immigration case, and of course, I accept the warning in the case is that you cannot simply cross-transfer from one case to another. But the driving rationale of the recognition of the power is to try and prevent the harm that comes with a decision which should never have been made. And if it can be said, well, if fraud was a fundamental mistake, one can certainly say, if fundamental mistake, why not administrative or clerical error? It's the same substantive harm that one is dealing with in either case, and that's what drives the decisions in this field. The need to protect the proper exercise of statutory powers to ensure that those who are entitled to rights get them, and those who are not do not. Because of course, when somebody is granted a particular benefit or right, there may be a consequential impact on the public interest. In a housing case, it's because somebody else cannot take the same housing. In a case of granting ILR, where it's not justified, then there is an indirect impact, if you like, because that brings with it an entitlement to all kinds of very valuable benefits.
Was the local housing authority functus in this case when it took the decision to rescind the early decision? Or
Well,
was it in a position where it owed the claimant continuing duties?
there's no discussion of that in the case.
No, I'm just asking.
No, sorry, I realise that. Can I come back to the court
Sure.
on that? In my submission, even if there was an ongoing duty, the answer to that would be the point that was raised in argument this morning about all the cases where the Secretary of State is allowed to withdraw decisions without any particular difficulty. There are plenty of circumstances where the Secretary of State reviews what has happened, reviews a decision that has been made in the immigration sphere, withdraws it and institutes a new decision. Now, the same objection could potentially be made there that the Secretary of State is functionless, but that's not done. But can I come back on that? There is a little case law on functus and withdrawing immigration decisions from some years ago,
Okay.
and it may be with the court's indulgence that we might look for that. I'm sure that is. Sorry, can I just turn my back for one moment?
So there's an express power to revisit the judicials. Okay. You'll need to get your money for permission. Maybe they will come back.
So just if it assists to this extent, my lady, my learned friend Ms. Masoodi is reminding me of paragraph 6
Yep.
of Porteous, which I began and then skipped over. That wasn't the intent.
It's a very long paragraph.
It's a very long paragraph. I'll use that in my defence if I can. That's the start of paragraph 6. I think I got as far as saying grounds 1 and 2 are closely related. Argument attractively presented by Mr. Glenn submits a decision to accept a duty to house in section 193 can only be revisited in circumstances expressly provided for under that section, subsections 5, 6, 7 and 7b, not necessarily to set them out, suffice to say they all relate to circumstances arising after decisions being made to accept a duty to provide accommodation. Duty to secure accommodation under the Act arises by reference to 193, where the local housing authority is satisfied that those tests are met. Nothing said about the local authority ceasing to be under a duty if no longer satisfied that the applicant is homeless. So runs the argument, the section being explicit as to the circumstances in which the local authority will cease to owe the duty. So the beginning of that looks as if it's saying that there are only particular circumstances where you can revisit. And the end of the passage seems to be saying that there's no suggestion that you are necessarily functus in those.
But it's a decision. It's a decision. The decision in question is a decision that you owe a duty. So
Yes.
you're not functus in relation to that duty. You continue to be under that duty.
No. I think what I'd like to do is have a look at the actual statutory
Yes, of course.
provisions because they're only summarised there, and come back to my lady on that if I can. Can I have permission to do that? I'm grateful, my lady. So what we say is that there's no rational reason in our submission that would justify the implication of a power in a case of fundamental mistake of fact, but not in the case of clerical error. We say it's impossible to understand where that distinction lies.
Well, they're totally different things. Fundamental mistake of fact is where you think the facts exist that would justify you exercising the statutory function. And clerical error is just somebody bogs up.
Well, they do.
I can't see that they're similar.
Well, my lady, they're similar because the outcome is the same. The outcome is the wrong decision. And it doesn't matter in my submission why or how you get there. One of the points about Porteous is that the argument being made was, yes, you can revisit, but you can revisit on the basis of the existing case law, only in cases of fraud or deception. Now, in fact, what the court said, well, why is that so? The harm is the same. And we say the same analysis applies when one compares fundamental error, which may be because you misunderstand fundamentally the facts on which you make a decision, and simply pressing the wrong button on the computer. The outcome's the same. The wrong decision comes out. It's not the case that on a proper appreciation you intend to be the decision. And the outcome
mistake is different.
I'm sorry?
The outcome may be the same, but the type of mistake is different.
Well, I accept that. I accept that. But the outcome here is what matters, because the purpose of the incidental power is to protect the public interest. If the outcome is that somebody who is not entitled to a benefit gets it, the public interest is harmed in the same way, whether that's because there's been a fundamental error or because there has been an administrative mess. So one looks, in my submission in these cases, and I'll come to see what the other cases say in a moment, but one looks at outcome and consequence for the public interest, because again, that's a consequence of public powers being conferred on the Secretary of State to be exercised in the public interest. So it does tie in with constitutional principle to that degree as well. Second case that I wanted to go to was the case of Fajimasin, which is in the same bundle and applies Porteous at tab 30. I just asked the court to turn up, so that's page 507. And these were disciplinary proceedings against the dentist, you'll see from the head note, on the basis that he'd committed fraud partway through the proceedings before the GDC's Professional Conduct Committee. The Registrar's Office wrote to him, taking his name off the register because he'd also failed to comply with the CPD requirements. So he was not just a fraudster, but also somebody who didn't comply with CPD. But this was done in error because they didn't know that there were fitness to practice proceedings on the basis of the fraud in process. And when the error was realised, his name was allowed to remain on the list, so in effect they withdrew the decision in order to allow the fitness to practice proceedings to continue. The dentist argued there was no jurisdiction to do so, no jurisdiction for the proceedings, because his name had already been taken off the list. Now this is a case which applies Porteous, and you'll see that. I can take the court first of all, please. And this is a judgment, sorry, I should say, of Mr. Justice Keith. And the relevant passage begins on page 520. You'll see there was some debate over the course of pages 519 to 520 about an earlier decision of this court in Kewishola's case, which was an immigration case about the Tribunals' powers, so not the administrative powers of the Secretary of State. And then the point made at the top of page 520 was there any reason not to follow that decision? And the reason given was yes, there's the case of Porteous. Porteous facts are set out. You'll see between letters D and E, although Lord Justice Michael didn't refer to Kewishola's case in his judgment, presumably because it wasn't cited. Porteous's case is authority for the proposition in addition to cases in which public body can revisit a previous decision under the equivalent of the slip rule. Public body can revisit a decision which was made in ignorance of the true facts when the factual basis on which it had proceeded amounted to a fundamental mistake of facts. And then you'll see the application of the case at 38. Can I just ask the court to read paragraph 38 in its entirety, please? if the court's reviewed that, you'll see that Porteous's case is applied. No suggestion of bad faith. There was a simple error. And you'll see at the end of paragraph 39, level just below letter C, if the appeal were to succeed, Mr. Fadjimisin's opportunistic reliance on a windfall of which he was the unintended beneficiary and of which he was unaware for much of the time would have been unjustly rewarded. Perhaps also worth seeing at the bottom of the page, letter H. Finally, the uninformed observer might be asking what the fuss has all been about. Mr. Fadjimisin wanted his name to be removed from the register and the fitness to practice proceedings have ended. With that happening, leaving aside the considerations which underlie GDC's policy of retaining on the register the name of a dentist who's subject to fitness to practice proceedings, the answer is that there are different consequences for Mr. Fadjimisin if he or she is removed from the register following fitness to practice proceedings compared with the consequences for the dentist if he or she is voluntarily removed because of a failure to comply with CPD rules. And you'll see then the consequences are set out in terms of applying to restore names. So again, a consideration in my submission of what the public interest requires in order to justify doing it.
Mr. Justice Keith makes, sorry to interrupt you, Mr. Blunt, at the very beginning of paragraph 38 is that both this case and Porteous involve decisions being made in ignorance of the true facts.
Yes.
Well, that's not the case here.
No, I accept
The
that.
Secretary of State knew jolly well what the true facts were.
My lady, I can, again, I hope I've made this clear, but let me say it again. I'm not suggesting the cases deal with the situation of the pure administrative clerical error. They don't. That is not my submission.
Right.
What I'm submitting is that they do recognise a jurisdiction in appropriate cases to withdraw a decision where there has been a fundamental mistake of fact. They have done so by way of incremental development from the principle that you can withdraw a decision where there's been fraud. And my submission is that it is a similarly narrow incremental development of that principle, meeting the same rationale and purpose of protecting the public interest in the proper exercise of statutory powers, to recognise that power in the case of administrative or clerical error. So I cannot point, and we haven't done this in the skeleton, we've not tried to put it in any other way, I cannot point to a case which is precisely on all fours with this. And the upper tribunal recognised that. They were quite frank about it. But in my submission, it is an entirely proper analysis, keeping with the common law tradition, by way of incremental development, an analysis of how the incidental powers doctrine applies to the powers in sections 3 and 4, to recognise that such a power exists also to remedy a case of administrative clerical error. And the reason why is because the impact on the public interest is exactly the same. Now, I think I said I was going to take you to 3 cases. That's the second of the 3. The third is Chowdhury, which is a useful development of the principles and attempt to rationalise what the power is seeking to do. Can I take you to that? That's in the second volume of authorities behind tab 33. And this concerns, again, it's disciplinary proceedings.
Page.
I'm so sorry, page 613.
Thank you.
Report begins at 612, text begins at 613. Again, it's medical disciplinary proceedings. You'll see paragraph 1, it's Mr. Justice Haddon K. Paragraph 1, case concerns the application of Rule 4.5 of the fitness to practice rules, which is a 5-year rule, which is essentially that that fitness to practice proceedings can proceed if a complaint is made more than 5 years after the most recent event giving rise to it. We've got the relevant provisions set out there. You'll see that Dr. Chowdhury challenged the defendant's failure to apply the 5-year rule in his case. So he was saying these proceedings are out of time. you'll see at paragraph 9 that the assistant registrar at the GMC examined the complaint at the outset on the 30th of July. She concluded Rule 4.5 wasn't engaged, made a note of it, said the complaint alleged between April and August that the doctor acted inappropriately. But then at paragraph 14, you'll see on the 1st of September 2014, Dr. Chowdhury's solicitors drew attention to the factual error in the decision. And they said that his last clinical encounter with the patient in the relevant period was not in August. That reflects an error on the part of the complainants. The GMC effectively had been inadvertently misled by the complainant's error. The last appointment with Dr. Chowdhury in the relevant period is on the 22nd of May. It was therefore outside the 5-year period and not within it. Then you get over the page, paragraph 15, the GMC confirming it was not prepared to revisit the registrar's decision and gave the following reasons. At the time the allegation was received, the registrar correctly determined that the 5-year rule was not engaged. The complaint was received on the July date, and it was stated that the last attendance was August. This is within the 5-year period. The registrar therefore determined to refer the allegations to examiners. One might think a slightly obtuse way of looking at the facts from the registrar.
Obtuse is a bit of a euphemism.
Sorry?
Obtuse is a bit of a euphemism.
I could use other words, but
Yeah.
probably not in this court. It was, obviously clearly wrong. Clearly wrong, but they wouldn't revisit it. So that's how the facts arose there, and one can see why Dr. Chowdhury wanted them to apply the provision.
Yeah.
You'll see page 623, sideline passage, in my judgment, paragraph 40, question of whether or not more than 5 years had elapsed since the actual date of the most recent events. It was an objective question of precedent or jurisdictional fact, common ground, that the date was wrong, should have been May and not August. The registrar was thereby led into material error when making her original decision. In these circumstances, the court has power to intervene and quash the decision and remit the matter for reconsideration. And then goes on to consider the refusal to consider. So the second question at paragraph 42 is whether it was unlawful for the GMC to refuse to reconsider and correct its decision. Rule 4.5 was not engaged. Once it was on notice, the original decision was vitiated by material error of fact. Only arises if I'm wrong about ground 1 above. So it might be said, I'll just make this clear against myself, it might be said that what follows is therefore obiter. Don't think that is what has been said against us, but one could say that on the basis of this being an alternative way to resolve the case, but there is a full and complete analysis of the relevant provisions and the principles. So we say it should, and in any event, the case is not binding, of course, on this court, but we say there's a valuable analysis of the principles that apply. So you then get paragraph 43, with the argument being advanced on behalf of Dr. Chowdhury that the GMC has an inherent or implied power to correct a decision made under a fundamental mistake or fact. That was opposed by Ms. Callaghan on the part of the GMC. There was then said to be a conflict in the authorities. You can see some reference to Wade and Forsyth at the bottom of the page. We've obviously been referred to Wade and Forsyth. We can take you to it as well. It features a lot in the analysis in a number of these cases for the analysis on incidental powers. And at 46, after citing the cases, including Kuishola, Porteous and others, Fadjimessin, 46, I respectfully adopt the analysis of Mr. Justice Keith in Fadjimessin, who followed the Divisional Court, and said Divisional Court, it actually said Court of Appeal on the head note, albeit 2 judges, Lord Justice Mantle and Sir William Aldous, which held that local authority had a power to revisit and rescind an earlier decision based on a fundamental mistake of fact. In my view, the inherent jurisdiction of public bodies to revisit previous decisions is not limited simply to correcting slips or minor errors which do not substantially affect the rights of parties or the decision taken. On the contrary, public bodies have the inherent or implied power themselves to revisit and revoke any decision vitiated by a fundamental mistake as to the underlying facts on which the decision in question was predicated. And you'll see then he has the heading broad corrective principle. I've no doubt that such a broad corrective principle exists in administrative law. Public bodies must have the power themselves to correct their own decisions based on a fundamental mistake of fact. To suggest otherwise would be to allow a process to triumph over common sense. No sense in requiring wasteful resort to the courts to correct such obvious mistakes. Administrative law should be based on common sense. and the vitiating effect of fundamental mistakes of fact is well recognised, and he refers to a number of authorities. 49, broad corrective principle of the nature described is consonant with the principles of proportionality and utility, also consonant with the emerging principle of good administration in administrative law. And again, he cites authorities, partly domestic, partly from the CJEU. Not to have such a principle would be inimical to good administration. In my view, the law is correctly stated in the current edition of Wade and Forsyth. You'll see that at the top of the next page, even where such powers are not expressly conferred, it seems that statutory tribunals have powers to correct slips, to set aside judgments obtained by fraud or based upon a fundamental mistake of fact. The principle would naturally operate subject to the ordinary principles of fairness in administrative law, which is an expectation of the rights of persons acting to their detriment in reliance upon such decisions. So the basis of the identification of the broad corrective principle there, I say, is as follows. First of all, it is a recognition that process should not dominate common sense. Secondly, it is an attempt to avoid wasteful resource to the courts to correct obvious errors.
I mean, is it possible to characterise pressing the wrong button as a fundamental mistake of fact, or you accept you have to push the boundary from what Wade and Forsyth have said?
So we have advanced the case on the basis of pushing the boundary.
Okay.
And the particularly given the exchange I had with my lady a few moments ago, the point is squarely put against me by my learned friend and recognised by the court that there is a difference between a fundamental mistake of fact, where you think something to be the case and it is not, and an administrative error where you simply press the wrong button, use the wrong template, something of that nature. But what I do say is that the boundary is not at all clear and distinct, and the consequence is the same. The reason I say it's not at all clear and distinct is because the consequence is the same, and because in both cases you have reached a decision which ultimately is an incorrect use of the statutory powers that you have been given to exercise in the public interest. So the broad corrective principle, and this in my submission is what Mr. Justice Haddon then was recognising here, is used to protect the public interest in that sense and ensure that statutory powers are only used for the right purposes and with the right results. So
with all respect, you might have gone a bit too far in paragraph 47, because it surely must depend on the statutory scheme that's being considered.
And again, my lady, I would accept that, because it's possible to conceive of a statutory scheme which, for whatever reason, perhaps because it dealt with it expressly, left no room for the implication. So there has to be room to imply. There has to be some kind of room to imply something which assists in the operation of the statute. So I accept that, and the cases, other cases are clear as well. You've been taken to some of the Supreme Court and House of Lords authorities are clear that you cannot simply, and I think this is also this court's decision in the PIF case, you cannot simply extrapolate from one statutory scheme to another. Of course, you have to see. But why Chowdhury is important is because it is recognising in principle the existence of that jurisdiction. So there may be cases.
But it might be said that it's not important in that respect, because it's making that statement in relation to the statutory scheme in question, number one, and number two, the premise of this supposed principle is that there's been a fundamental mistake of fact which vitiates the decision in question.
So 2 points, Malin, in response to that. First of all, yes, he's dealing, of course, with a specific statutory scheme, but he was the third judge to deal with a third statutory scheme. So this was the GMC statutory scheme. You had Mr. Justice Keith dealing with the GDC statutory scheme, and you have the quite different context of Porteous dealing with the homelessness statutory scheme. So in my submission, it was unsurprising that the judge in this case said there is a broader principle at play in public law, which is to do with good administration. The second point is that in any event, in my submission, and this goes to the point about he was dealing with fundamental mistake of fact, as I've already indicated, I accept
You're pushing the boundaries.
I accept that I'm pushing the boundary, pushing the envelope today.
All right.
And that's, I can't avoid that.
No.
The cases are different. But I do ask the court to stop and pause and contemplate why it is wrong to push the boundary in that way. If the harm to the public interest is the same, then the rationale that exists and is recognised in the material error of fact cases is there as well. Now, I would be in different territory if I was asking the court to recognise a principle based on no case law that did not have the same guiding principle at its heart. That would be much more difficult in any common law system. Although this is a process of statutory implication, it's obviously based on seeing what the common law allows you to do by way of that process. So it has to be incremental, I accept that. But it's incremental based on what the law has identified as the rationale. And that's why I do say Mr. Justice Haddon Cave's analysis in Chowdhury is important. I say he's not the first judge to identify the power in one scheme. This isn't just in one area of law where you could say, well, that's very particular to professional regulation for dentists, or it's very particular to housing. They're all happening. So if there is room within the statute, and I've already made my submissions on sections 3 and 4, and why I say there is room there for the implication, then it can be done. So it's a pushing of the boundary, but only in a very gentle and limited way. And perhaps also critically, what you can take, which again was in some of the cases, but more clearly here, is his concluding observation at paragraph 51, that it's not an unlimited principle of unlimited scope. There is public law control. Now, Mr. Mackenzie says against me, well, that's not of much consolation to an individual who has leave withdrawn. Of course, I understand that. That is a very human submission made on the basis of impacts of powers like this on real people. But it's not just this person who matters. Yes, he's a beneficiary, but there are others who have a converse interest in the right people being granted leave for the right reasons. That's the public interest, the silent third actor in all of these cases. So I do say that's a powerful countervailing, counterbalancing consideration there. And for those reasons, my submission is there is recognition of this principle. My boundary pushing is highly limited. And indeed, in terms of consequence, there's no boundary pushing at all. Consequence is exactly the same. And Malone and Friend has not identified any different consequence in terms of harm to the public interest, I respectfully say. Now, the second stage, which I'll try and take more quickly, is to deal with the immigration cases on incidental powers. Now, the key case, obviously, that we've relied on, although there is one other case as well that does recognise this to some degree, is the New London College case. You've been taken to the relevant passages. Can I just perhaps ask the court to send it up very briefly again? It's behind tab 29 in the first volume. Don't seek to go through it in any great detail, given that you've seen it.
Page.
I'm sorry, case begins. So I'm going to take you to page 499.
Thank you.
Given that you've seen some of this already. And the point my friend rightly made was that it was really the intervener's arguments that properly engaged the analysis from Lord Sumption and Lord Carnworth. And you'll see them summarised in paragraph 23. It was a more pure form of the argument advanced by Mr. Drabble. You'll see level letter C. He said the sponsor guidance doesn't fall within section 1.4 or 3.2 and hence the rule provisions. He says not directed to regulating the grant of leave to enter. But he says because control of immigration is wholly statutory, there's no power to control it otherwise than by rules falling within section 3.2. There's no power to operate a system of sponsor licensing at all. Only on the footing that contrary to that submission of Connors did fall within those provisions was he able, by way of alternative, to give at least a partial support to the claimant's argument. So what's said against me is that I think in effect it's not dealing with the same point because it's not dealing with the rule provision. Well, that's right, but the answer given Bible assumption over the page, at page 501, is actually precisely to identify that the immigration system contains implied and incidental powers. And true, it's dealing with a different part of it, but there is no objection to the implication of powers in immigration more generally. I'm going to speak to one other case where there is a suggestion actually that there are implied powers even in the grant and leave context. So paragraph 28, page 501, you'll see this, an assumption saying that Mrs. Drabble's submission is unsupported by authority, not right in any event in principle. Long recognised that there are certain general administrative powers, they're controversial, they're the third source powers. At the bottom of the page, 3 lines up, the question doesn't need to be resolved on these appeals because the statutory power of the Secretary of State to administer the system of immigration control, that must include, as well as the things that are not leave to enter in the main, the things that are leave to enter in the main, must necessarily extend to a range of ancillary and incidental administrative powers not expressly spelt out in the Act, including the vetting of sponsors. And then you'll see, just below letter C, the right is, of course, not unlimited. Secretary of State cannot adopt measures for identifying suitable sponsors which are inconsistent with the Act or the rules. So consistency with statutory purpose, effectively. Without specific statutory authority, she can't adopt measures which are coercive, which infringe legal rights of others, including under the Convention, or which are irrational, unfair, or otherwise conflict with the general constraints on administrative action contained by public law. So in terms of controls on the implication that may be made, the incidental powers that may be granted, those are the controls. And wholly unsurprisingly, they're the usual public law controls. You similarly get a finding as to the existence of implied powers by Lord Carnworth at paragraph 33 and 38. Don't ask you to turn those up, just to give you the note that that's where they are. So my submission, there is a recognition that there are incidental powers that can be implied into the immigration statutory regime, and that is clear from the New London College case. I should take you to just one other case, which is the case of Hashmi. This is behind tab 22, so the same bundle. Now, this is one of the cases.
Could you give us the page number, please?
I'm so sorry, 365.
Thank you.
So this is one of the cases that the tribunal distinguished, effectively at first instance, and said this doesn't really provide the answer. The facts are set out in paragraphs 1 to 8. In summary, Ms. Hashmi is a Colombian national who entered the UK as a spouse of a British citizen. She was given limited leave with her children, had various extensions and travelled on various occasions. The Home Office at one stage lost the passport of Ms. Hashmi and indeed her family members. You'll see that from paragraph 4, and that's said at the end of paragraph 4 by Sir Swinton Thomas to be a relevant factor in looking at what happened afterwards. Paragraph 6 records that she applied to extend her leave to enter to indefinite leave to remain. She was advised that was premature because she still had leave to remain in the country. She engaged the assistance of her MP, Ms. Jowell, who wrote to the Home Office, and you'll see at paragraph 7 that the Home Office effectively decided exceptionally, because it had mislaid the family's papers, to grant her indefinite leave to remain. So she delivered passports to the Home Office to be endorsed with indefinite leave to remain. But at paragraph 8, you'll see that before the indefinite leave to remain was granted, there was a change of circumstance. So her husband and her husband's solicitors wrote to the Home Office saying that the marriage had broken down and he no longer supported her application for ILR. So between those two dates, on a number of occasions, the appellant and their solicitors pressed the Home Office. Eventually, you'll see the decision recorded at the end of paragraph 8. Your client's application is being refused as their marriage is no longer subsisting. The requirement for ILR for the spouse of a person presently settled is not made out effectively. So it's a change of circumstance case. So it's different from this case. I'm not relying on this to show that this demonstrates the exact same scope of power to act. And you may recall that in Porteous, the point was made that change of circumstances cases may be different from cases focusing on what happened at the time of the decision in question. But it's worth looking at what was then said about what had happened. So if one turns over to page 368, the first issue at paragraph 13 is whether the letter of the 11th of July amounted itself to a decision. So the 11th of July letter was the letter at paragraph 7, where the Home Office said we're going to grant you indefinite leave to remain. And what the court finds at paragraph 14 and 15 effectively is that it was a decision. In immigration cases, decisions are frequently given by letter. In my judgment, the contents of that letter are clearly communicating a considered decision by the Home Office. Then more reasons given. Paragraph 15, in my judgment, those words clearly have the connotation that leave has been granted and can only have that connotation. All that remained was the formality of the submission of passports, and the writer of the letter would then arrange for the documents to be appropriately endorsed and returned to the family's home address. There's then reference to Minton, it's the case you were taken to this morning, and then you'll see at the end of paragraph 16, in my view, that case doesn't assist the respondent on the facts of this case. Stamping of the passports itself does not amount to a decision. It may evidence the decision which has previously been made, but the stamping is an administrative act following the decision having been made. That then leads to paragraph 19. The next point is taken on behalf of the respondent, which is one which appealed to the learned judge, is that the letter did not constitute notice in writing to the appellant as required by section 4. It was sent to Ms. Jal and was addressed to Mr. Hashmi. In my judgment, both those individuals are acting on behalf on and as representatives of the appellant when the respective letters were written, so that was no proper objection. And then you get this at paragraph 20. I would accordingly conclude that the letter of the 11th of July did constitute the exercise by the Secretary of State of his power to grant ILR. Short of exceptional circumstances, such as leave having been obtained by fraud or misrepresentation, that leave, if properly granted, cannot subsequently be withdrawn merely on the basis that there has been a change of circumstance. Now, what I say about this, and this was a case in 2002, is that to suggest that there's been no consideration about whether you can withdraw leave, whether effectively you can apply a power to withdraw leave in any other circumstances, has been at least considered to that extent by the Court of Appeal on one previous occasion.
This is over, isn't it?
Well, my lady, no.
I mean, I may be wrong, but did the Secretary of State argue that there was some power to, even if it was a proper notice? I mean, I see the points taken about this isn't a proper notice in writing. Was the Secretary of State arguing that there was some power to revoke ILR because circumstances had changed?
Well, in my submission, that clearly is the implication in paragraph 20, that was part of the argument the court was dealing with.
I'm not sure, because the submissions made by
Ms. Rose.
Miss Rose, as she then was, are pretty fully set out. And I mean, I've only read this very quickly, but they don't seem to include a submission that there's some residual power to withdraw it.
Well, first of all, in my submission, the proper analysis of that paragraph is that that was a submission that the Court of Appeal was dealing with here, and therefore it is part of the ratio of the case. But secondly, even if it's not, in my submission, there is no reason not to follow it to this degree. I'm not saying, again, that this indicates that you have exactly the same power, implied power, incidental power, to withdraw as in this case. I've still got to make that journey beyond the circumstances. But what it does mean is that at this stage, there was considered to be an exceptional circumstances power to withdraw. The examples that are given are fraud or misrepresentation. Now, this would be at the same time as Section 10 was in force.
So this is before the amendment made by the 2002
Yes,
Act?
it was May 2002.
But I mean, I'm not convinced at this point was argued.
And I'm just checking the date of Section 76 came into force.
Section 76 can't have been in force at the
No.
date of the material facts, because the decision of the High Court judge was in 2001.
My lady's absolutely right, exactly.
And the events in question all happened in 1999 and 2000.
But what you did have is Section 10 at this stage of the 1999 Act,
But I mean, there's no trace that any of that was relied on.
No, but what is the case here is that there is a recognition of a relatively broad power in exceptional circumstances. So not an easy test to satisfy, but which is not limited only to fraud and misrepresentation. They are examples given.
Well, as I say, I'm not persuaded that was an issue in the case. But anyway, I've got your submission.
But that's the only purpose that I seek to take you to for, because it's said that there's been no consideration at all by the courts. Now, it may be that the point is overturned. But either way, it is something which the courts have considered some time ago and apparently recognised to that extent. I can't take it any further than that, but in my submission, it is useful for that purpose.
Right, and how are we doing? I'm just conscious that we've got a reply to fit in.
My lord, I can take it much more quickly from here.
I'm not stopping anyone. I'm just trying to encourage us to keep on track.
No, I've done what I needed to do with the immigration cases. The only other analysis of any of the cases was the immigration cases that the tribunal held were not relevant. Now, I don't need to go through that in any detail, precisely because they're not relevant. I'll just give you the headlines.
Yeah.
And in a sense, I've done this as I've been going through, but there's only two of them that my learned friend dealt with this morning. So first of all, there was RAM. Well, in my submission, that's a case on a very narrow scope. It's a habeas case. It examines the circumstances in which somebody can properly be held to be an illegal entrant, and it is authority for the proposition that if there is a grant of leave that is in force, then that can be relied on, and a grant of leave even by mistake can be relied on unless it's been quashed, or we would say withdrawn. It goes no further than that. In a sense, it is Hoffman, LaRoche or Magira in action, and in my submission, it's no answer to say to our case today that, well, the Secretary of State could have argued what she's arguing today at the time of ex parte RAM. It was dealing with a different point. The man was in detention, and that was the case that had to be met. It doesn't assist at all. Hashmi I've dealt with. The only other case my learned friend relied on was Rachachi, the decision of Mr. Justice Davis. Don't seek to go to that at all. What I say is that was dealing with an entirely different point.
That's same as Colombo, isn't it?
Colombo, exactly. Yeah. So Colombo was there were a number of different individuals.
Yeah, no, it just depends how you refer to it. Fine,
yeah,
thank you.
But my lord's exactly right. It's Colombo. So actually, the key issue in the case is, was the Secretary of State entitled to change policy from ILR to 5 years for refugees? Answer: yes. The analysis you were shown about Colombo was simply effectively the case-specific disposition of that case. Can I just go to one passage only, which is paragraph 97?
Only if you give us the page number.
To 380, my lord, behind tab 24.
Paragraph 97.
And 97 then is at page 404. So the case begins at 380, 97 is 404. And you'll see three short points made there. First of all, Mr. Colombo and his advisor didn't contribute to the mistake. Well, we accept that's the same here. The question was effectively how do you construe the particular status document that he's got, and you'll see the content of the vignette in question is summarised at paragraph 82, and the court found that that was a grant of indefinite leave to remain. Secondly, at 97.2, Mr. Colombo and his advisors could not have assumed he was bound only to be granted 5 years leave to remain. On the contrary, the RLC on his behalf had shortly before the issue of the document been writing letters urging the Secretary of State to grant him ILR. Now that's relevant because I took you to the submissions in this case which precisely don't do that. So quite a different case from this one. And then the third point, which is the one ranged against me, is that Mr. Justice Davis says my attention was not drawn to any statutory power entitling the Secretary of State to revoke or alter a status document. Well, that's true, but that doesn't assist. The point just wasn't argued because, again, what was being argued is how do you construe the document? There'd been no attempt to withdraw it because the Secretary of State says it doesn't mean what you think it means. So it's of no assistance for that reason. And then against perhaps just one final authority I should show you before I make some submissions on my learned friend's arguments. But referred to Wade for sight, and he referred to our reliance on it as well. I don't think you've seen it this morning, but if you turn behind tab 47 at page 1019,
We were showing this as well.
I'm sorry. I know you were given the reference. I didn't take it. Can I take you back anyway?
Of course, yeah.
So 1019, acts reasonably incidental at the bottom of the page. Statutory power will be construed as impliedly authorising everything which can be fairly regarded as incidental or consequential to the power itself, and this doctrine is not applied narrowly. And then the example is, sorry, yes, because you were given the example of the book binding. If you look in the footnote, the source is some of the old railways, Ultraviaries cases, so Great Eastern Railway, Smethwick Corporation as well. Contrast the more restrictive approach taken in Ward and its Lady Hale, it is not sufficient that such a power be sensible or desirable. The implication has to be necessary in order to make the statutory power effective to achieve its purpose. Now, I go there because that's the narrow expression of the principle, and that is perhaps slightly narrower than the New London College case, which is also cited in the footnote. So both cases are cited, but even if that is the test, I say we meet it. This isn't a case where we're dealing with something which is sensible or desirable. It is much more than that. It is essential to enable a statute to function consistently with its purpose. That's why I said part of the purpose here is the proper granting of leave in accordance with the rules. See the primacy of section 3.2 given to the rules by being laid before Parliament, and then the provisions 3.1b and section 4 as well. So I say we do meet that test, and that's why I wanted to show you that provision. Shall I then take you finally to, just very briefly, 5 objections that my learned friend has made to our particular case. The first, I need to say no more about. It's that he says none of the immigration cases assist. Well, I've taken you to Hashmi, which shows the point has been considered at least before. It's not as novel as is suggested. I've taken you to New London College, which shows that it's certainly accepted implied powers in the immigration sphere. And then more significantly, I've taken you to the general public law cases, which show a well-recognised power in a number of differing areas of public law of a corrective principle. In my submission, for the reasons I've already given, it is no great development, and in fact a very minor development, to develop from material error to administrative error or clerical error. That's point 1. Point 2, Mr. Mackenzie says Parliament has spoken in section 96, and its silence here speaks volumes. Well, first of all, it's only spoken in a very limited way. It has introduced a power, consolidated a power to some degree from section 10 to revoke in very particular circumstances, each of which involves the individual beneficiary having done something to call their leave into question. So there's...
Well, the fact that Parliament's intervened in a very limited way might be thought to favour the argument you have to confront, not to favour your argument, because if Parliament's made a specific provision enabling revocation in limited circumstances, it's very difficult to say, oh, well, I can rely on implied power to let me withdraw, revoke, change, or whatever decisions in different circumstances.
My submission, my lady, respectfully, I say that's not the case here, and 2 reasons. 1, first of all, there is a fundamental categorisation difference between the intervention that's occurred through parliamentary action in section 76 already, which is effectively deportation but legal barrier, deception, or voluntary re-availment of protection in the refugee context. So the individual doing something specifically which calls into question a leave validly and properly otherwise given. And in those circumstances, there has to be intervention in the public interest so that the Secretary of State can say, you no longer deserve that leave. That's effectively what Parliament is doing there. It's quite different where you have the implied power, which is simply to correct an error that's been made. The leave never should have been granted. So it wasn't even within the scope of what Parliament was doing by enacting section 76 to deal with this separate issue. They're categorically quite different areas of parliamentary action and of the public interest, the public interest, is a different one. So the public interest in the Section 76 cases was perfectly properly satisfied when anyone in any of those three categories was granted their leave. There's no suggestion they were not granted leave correctly. It's different in this case where they were not granted leave correctly. It's a different public interest, so it's not something which Parliament was entertaining at the time. That's the first answer. The second answer is to say that actually the courts, despite what my learned friend says, have been exceptionally cautious about the informed interpretation or Barras approach. And can I take you to two authorities to demonstrate that? One, very briefly, is Robinson, which you've already seen this morning. This is a passage you weren't shown, behind tab 34. Begins at page 629. The relevant passage is in the judgment of Lloyd Jones, with whom the other justices agreed. You were taken to paragraph 62 at page 658, but at paragraph 63, it's important to see this. I should, for the sake of completeness, address two further matters arising from Mr. Forden's submissions in this regard. First, it would not be appropriate to speculate as to why Section 12.3 of the 2006 Act has not been brought into force. But in any event, in seeking to ascertain the intention of Parliament, the Court must have regard to the legislation as enacted, and there's a reference then to the ZA Nigeria case, Lord Newberger as Master of the Rolls. So what you have regard to are the actual words that Parliament used, not the parliamentary silence, the void that's otherwise left. And that
He's dealing with a different point there. The
Well-
point I'm making is just a basic approach to construction, is where you've said, made a specific provision about something.
Yeah.
You can't then imply something that goes wider than the specific provision that's being made.
So I'm sorry, I was dealing with, that's my mistake entirely.
Yeah, no,
I
it's
thought
my fault. No, sorry,
it's definitely me.
my fault for not
I
not
thought a
being
different
clear
point was being
about
put
the
to me.
point I was trying to
That I entirely accept, but then one has to ask, well, what's the provision that's being made? So my answer to that is, what is Parliament doing in Section 76? Is it saying, this is the power of revocation in all and every instance, and thou shalt not go wider than this, thou shalt not trespass any wider than this specific statutory turf? In my submission, no, it's dealing with a particular issue, which is how to bring to an end leave in particular circumstances where it's been entirely properly granted, but because of later events, and again, consider the contrast in Porteous and the other case. You've got all that,
understand
yeah.
your submission.
But my lady, I do have to press that slightly, because it is a fundamental distinction there. In the category I'm dealing with, it's nothing to do with a later supervening event. Something's gone wrong at the outset. And it makes, indeed, in my sense,
Fraud isn't a later supervening event. It's something that might be thought to vitiate the grant of leave ab initio.
except that fraud typically will only come to light later. If you knew of the fraud at the time, you probably wouldn't grant. So true, that may reach back to a degree in time, but it's only coming to light later in the day. So it's a different situation though, where the mistake is not an error on the part of the individual beneficiary, but a mistake on the part of the Secretary of State. And then in my submission, and adopting the analysis, the good administration analysis of Mr. Justice Haddon Cave, it makes far more sense for the remedy to be the internal one of the Secretary of State acting in that implied way. So in my submission, that there's no improper trespass in that situation. The different point that my lady wasn't making to me, which I thought my lady was one that I was going to go to in any event though. So and this is my third point out of the five, which was that you also need to see, in considering the informed interpretation analysis, the case of ZH and CN. Can I just I'll take you to it very quickly and give you the references. I won't go through it in any detail. It's in volume 2 of the authorities, and it begins behind tab 32 at page 535. The headline submission from me is that all of the justices in the Supreme Court urge extreme caution before adopting an analysis or interpretation based on parliamentary silence. So first of all, Lord Hodge, with whom Lord Wilson, Lord Clark and Lord Toulson agreed. This, I think I'm right saying, was a 7-judge cause. Yes, 7 judge cause. At paragraph 53, page 580, you'll see between letters B and C, suffices for me to say that where Parliament reenacts a statutory provision which had been the subject of authoritative judicial interpretation, the court would readily infer that Parliament intended the reenacted provision to bear the meaning of the case order already established. And you'll see some further references there. But then at letter D, inferences from parliamentary inaction are more difficult. In my view, the settled practice principle of which Lord Carnwath writes is available where there is ambiguity in a statutory provision, but for the reasons set out above, I detect no ambiguity. Section 3 of the Protection from Eviction Act. You then see next Lord Carnwath at page 587, at paragraph 81, the heading tacit legislation. And you'll see there's a reference to Sir Chamberlain as he was his submissions based on Bennion. And at paragraph 82, I have difficulty with the phrase tacit legislation. As Lord Nichols made clear, Parliament legislates by what it says and what is said under its authority, not by what it does not say. Anything else can only be justified, if at all, as judge made law. And then at paragraph 85 over the page, in any event, we were referred to no authority which has applied that principle to a case, whereas here the most that can be said is that Parliament's failed to take what might have seemed an obvious opportunity to legislate. Absence of legislation may be governed by many factors which have nothing to do with the perceived merits of a possible change, not least parliamentary time and other government priorities. There's many reasons why Parliament doesn't legislate. Then just to give you the other references, I won't go through all of them, but paragraphs 143 to 147, a similar, in my submission, scepticism about parliamentary silence from Lord Newburger. And finally, at paragraph 167, again, the same concern from Baroness Hale on page 610.
So do we need to worry about any judgments other than the judgment of Lord Hodge, with whom 3 other...
If you get a majority.
Yes. So do we need to worry about what anybody else said?
Not in particular, but they are expressing in my submission, they are adding, no, you get the majority from Lord Hodge and he's good enough for my purposes. I've taken you to them because they are decisions of the justices.
I am conscious of
Yes.
time.
I
And
don't
Mr
think
Mackenzie,
there's
you'll likely be, what, 20 minutes?
Well, my lord, I had uncovered a case about the powers to withdraw to answer my
Right.
questions. I'm very happy to do a written note on that. Indeed, my learned friends might appreciate the use as well. If I don't have to make oral submissions on that, then maybe I'll try and be over within 10 minutes, yes.
Okay, well, that's fine.
Well, no, I need only 2 minutes.
No, I don't want to stop anyone.
No,
I mean,
no,
they're important points, but I do want to finish by 4:30.
No, of course. My lord, I only need 2 minutes. I don't need to say to you anymore. My lady is absolutely right. Lord Hodge is good enough for me. I've taken to the other analyses because they are significant and comprehensive analyses of the difficulty of the point and worth reading, and consistent with Lord Hodge. The 4th point is the argument that this has never been covered in the Secretary of State's policies. Well, that's true. I can't suggest that it has been. You won't find it in any of the guidance. The answer, we say, is that the Secretary of State doesn't have to have a policy on everything. This is not the kind of area in my submission where we would anticipate she would have a specific policy about what she does when she makes a mistake. The question is whether she has an implied power to deal with it. I'm not suggesting she's coy about her mistakes, but it's just simply not the kind of thing we would expect to see in guidance. I'm not going to enter the territory of how often the mistakes happen. It probably won't end well for me. That's what I say about the policies. And then 5thly and finally, no retroactive cancellation of leave. Well, we respectfully say that is a non-point. It has never been suggested in this case, certainly in the upper tribunal and here, that there was any retroactive application. Just to give you the reference where this was made clear in the detailed grounds. Yes, in the detailed grounds drafted by Malone Jr. At page 194 of the bundle, top of the page, paragraph 92. If it's a decision that's withdrawn with the result, decision must be remade. The effect of the withdrawal is therefore prospective only. The reason why the letter bore an earlier date was simply because it was replacing the incorrect grant of leave. It wasn't because it was seeking to act retroactively in any way in that sense.
So I still don't understand the stuff about the dates. There's no evidence, as I understand it, from
No.
the tribunal explaining any of that.
The days, my lady's right. No, I can only say that on instructions to answer the court's question. I'm told it was a simple error. But the point is, it was not argued that the new decision was in any way retroactive, and that was consistent with the Secretary of State's approach. In my submission, the language used by the tribunal was not inappropriate and didn't suggest anything otherwise. It certainly doesn't say it was a retroactive decision in any way, and nor could it in light of the authorities. My Lord, may I just have a moment to turn my back?
Of course.
The only thing I haven't dealt with is PIF. All I was going to say about that was it's a very different statutory scheme. The question in PIF, as I understand it, was about Section 12 of the Interpretation Act and whether that could be used to imply a particular power there. And the answer was that no, it couldn't. It was rather a principle that allowed you to say provisions can be made from time to time, or statutory powers can be exercised from time to time. We say that's of no assistance in this particular case. My lady, my lords, unless I can assist further, those are my submissions on behalf of the Secretary of State.
Okay, thank you very much.
Can I thank the court? I'm a learned friend for allowing me to speak for a little longer than
Thank you.
anticipated.
Ms. Masood. Thank you. Mr. McKenzie.
May I hand up for an authority? May I perhaps make some progress on the other points I wanted to make, and then come on to this? And if we are running out of time, then perhaps we could do a short written note.
Yeah.
This is to answer my lord's point about
Thank you.
withdrawal. So you should have there the Rule 17 of the first tier tribunal rules, Rule 17 of the upper tribunal rules, and a judgment called Chichvarking. Before I come on to those other points, I just wanted to make briefly, I had about eight points, I think, but most of them are quite short. First of all, in my respectful submission, much of what we heard from my own friend constitutes reasons why it may very well be convenient or helpful for the Secretary of State to have this power, which he contends none of it was about it being necessary to have that power, which is the test, of course. So that's my first point. The second point, just very briefly on the last point Melinda made, which was non-ratification cancellation. Yes, I accept that that was the point made in the detailed grounds of defence, but unfortunately the tribunal doesn't decide the case on that basis. Thirdly, the decision being unlawful. Well, of course, it doesn't follow from the fact that it was made outside the rules that it was unlawful. I don't think it's been explained how it was unlawful. The Secretary of State has very wide powers outside the rules. And in any event, it's not really relevant because Madeira and Vassar, the cases which been referred to, say that a decision, whether it's a judicial decision or an administrative decision, remains valid unless set aside. Madeira in the Supreme Court expressly says at paragraph 56 that invalidity of a decision is not a defence in judicial review. That's in relation to a judicial decision. At Vassar, Lord Justice Lewis at 68 onwards is to very similar effect. So it's not in any event, of course, the Secretary of State didn't raise this point, having been given the opportunity somewhat reluctantly, I think it's fair to say, by the upper tribunal in its order drafted submission, that they were prepared to hear argument on it, and the Secretary of State didn't pursue the point. So that's my third and I think probably fourth point. Then just coming on to the cases my learned friend has looked at, obviously without wishing to repeat myself, these are all in different statutory contexts, but just a couple of points on them. So Porteous, which is the housing case, one of the points that arises in Porteous is that the applicant was still the tenant at an address in Chiswick, I think it's called Edenshaw Gardens. Now, it seems to be accepted that was an honest mistake on her part, but it's still a mistake by her. So to some extent, she had induced the error. And if one looks at page 377 of the authorities, paragraph 9, towards the bottom of 9, about halfway through 9. Although from my part I would hesitate to adopt the judge's condemnation of the applicant as having been guilty of material non-disclosure, certainly the case of a more fulsome account of her tenancy at 108 Edenshaw Gardens might well have alerted the local authority of the possibility of accommodation still being available to her. Except that section 184 is the duty to make inquiries. It does impose a duty on the local housing authority to make inquiries. That doesn't itself relieve an applicant from an obligation to include all relevant information. Whilst I recognise that there may well be a distinction to be made between circumstances prevailing at the time of the decision and changes occurring thereafter, I felt the judge was right to find that local authority we do and we sin. So, although there may not have been deliberate dishonesty, there had been some fault on the part of the applicant. And of course, the applicant in that case is asking the local authority to expend scarce resources on housing her when she doesn't require to be housed because she's already got a home. In circumstances where, of course, the resources she's asking for from the local authority could be provided to someone else. So there is, to some extent, a zero-sum game there. Somebody else is losing out. But that's not the case here. Nobody is losing out because this appellant has got ILR. There's no parallel at all. His ILR doesn't have an impact on someone else because there's not a limit on how many people can get it. So that's Porteous. Fagemissin, I think my learned friend said that Mr. Fagemissin's, this is the dentist, of course, Mr. Fagemissin's name was taken off the register, but in fact it wasn't, and this is part of the point that we made in our skeleton when we addressed it. But if one looks at paragraph, one looks at page 507 of the authorities, and so that's the beginning of it. It begins at page 507 in tab 30, paragraph 12 is page 511. So in fact we see that although a decision had been made to remove his name from the register, in fact it had not yet been removed and he'd never been told it was going to be removed. So the decision, although the decision was made, it was never implemented and it was never communicated to him. He'd never been told he was going to be struck off and he hadn't in fact been struck off. So a very different situation, we would say, to a decision which has been implemented and communicated. And again, one has to look at the context. The court is concerned with the public interest of not allowing somebody to practice dentistry when they may have committed fraud, and concerned with not allowing them to avoid legitimate disciplinary sanctions by means of, by reason of a fortuitous, irrelevant set of circumstances. And obviously it's been accepted, it's widely accepted in the immigration context that uncommunicated decisions can always be revisited. And then finally...
What's the Anna Frujeva, if you haven't communicated the decision, it's not a decision.
Well, yes, indeed, also that, yes, indeed, my lady, yes. And then finally on the cases, my learned friend referred to Chowdhury, the doctor, and the GMC. As was apparent, I think, from the passages my took you to, the miscalculation of the deadline, the 5 years, I think it was, deadline, was jurisdictional. So the GMC only had power to pursue the disciplinary proceedings at all if they were within the 5 years, unless there were exceptional circumstances, and it hadn't determined that there were any exceptional circumstances. So if there's a parallel at all, again, the parallel with Chowdhury in the immigration context would be a case where there's no power to grant leave at all. And then I would respectfully concur with what the lady said about Mr. Justice Haddon Cave having perhaps gone a little bit far at paragraph 47. I don't, well, perhaps he didn't intend, with respect to say that all public bodies have the power to revisit any decision. Indeed, it would seem that he can't have intended to say that, because that would be contrary to the principle that it's always dependent on the statutory context. And of course, all of these cases are mistake of fact cases. And all of that perhaps helps to explain the different outcome in Piff's Elm, particularly paragraph 100 of my lady's judgment. What's said at 100 suggests, in my respectful submission, that the court should be more reticent to imply a power to revoke or rescind an exercise of a function in comparison to a power to rescind a rule, and clearly points to the concern of Parliament, or clearly points to Parliament seeing implied powers to revoke or rescind differently to other implied powers. And then what's said at 101 of Piff's Elm is consistent with what I said earlier about one needing to look at the substance of the action rather than the name which is given to it, whether it's revoke or withdraw. And then N and Lewisham and tacit legislation, I mean, as I hope I made clear this morning, I accept what's said about that, but this is a point, the point is that here there has been legislation on this exact point as to when ILR can be taken away. So this is not a situation of complete parliamentary silence. This is a situation of parliamentary intervention on this exact issue, but not achieving what my learned friend wishes to achieve. So a very different situation from this.
I'm sorry to interrupt. What do you just say to Mr. Blundell's, I think, was the last point, which is, albeit in the context of the Secretary of State policy, Parliament's unlikely to sort of legislate saying Secretary of State can correct her errors. You know, you don't normally legislate assuming that people are not going to get things right.
Well, I would refer back to the point I made this morning, which is that there have been cases, Ram is one, Richachi is another, Mr. Kalobo and his vignette, where people have, and Mr. Minton, all of those are cases where the Secretary of State has made a mistake, the person has ended up with ILR, with what I call a windfall. Parliament could have legislated to end those windfalls and did not. Did legislate to some extent to deal with the Minton situation, legislated to say, well, you don't get ILR just by default because you haven't been given leave within 12 hours of your examination. Legislated to change that to 6 months. So there's been frequent legislation in this area. Sorry, not frequent legislation. There has been legislation in that area. There have been a number of cases in this area where Parliament could have stepped in to say, well, you know, we consider the Secretary of State should be able to rectify these errors, has not done so. And perhaps more importantly, as to the existence of an implied power, nobody has ever suggested that that power existed. Nobody suggested that Mr. Minton should have his ILR or could have his ILR taken away. Nobody suggested Mr. Ram could have his ILR taken away. Nobody suggested Mr. Kalobo could have his ILR taken away. And certainly in the Kalobo case, that would have been a complete answer to his case. Perhaps not in Mr. Ram, where he'd been detained. But the point is that the Secretary of State, if the Secretary of State wants you to discover the existence of this power, that is, despite what my learned friend said this morning, a distinctly novel proposition which has never been advanced before and never found by any other court. I don't know if perhaps I can just very quickly take my lords and my lady through Chichvarkin. I think I'll do 4:30. So you have here, as I say, let's start rule 17 of the first tier tribunal rules. So 17.2, the tribunal must say for good reason treat an appeal as withdrawn if the respondent notifies the tribunal and each other party the decision, all of the decisions, to which the appeal relates has been withdrawn.
But that can't give the respondent the power. That assumes that the respondent has a power.
It assumes the power, yes. Clarkin helps us there, I think. But it certainly assumes the power. And likewise, Rule 17 of the UT rules, 17.1, either party may give notice of withdrawal of its case. So Chitvarkin is a case where essentially the Secretary of State, upon, well, just to go back a moment, Mr. Chitvarkin and his wife, Ms. Chitvarkina, applied as investors and were refused. And at that time, they had a right of appeal against refusal. That wouldn't be the case now, of course. And during the course of their appeal, they claimed asylum, and they did so correctly on the basis, I think they were entitled to raise asylum grounds on any appeal at that time. So in any event, the point is that they claim asylum, and the Secretary of State then withdraws the decision because she wants to consider the asylum grounds that they put forward, and the Chitvarkins take exception to that, and they try and judicial review of the Secretary of State's decision to withdraw the decision. They want their appeal to continue. So, yes, sorry, the context is paragraph 27 of the judgment, making reference to section 120 of the 2002 Act, which is the requirement to provide line 7 other reasons or grounds on the basis of which the person wishes or believes he should be permitted to leave to enter or remain. It's called a statement of additional grounds. And then under section 82.1, this is line 8 or 9, I think.
So which paragraph are you on?
Sorry, 27.
Yeah.
So you have a right of appeal. You then you can be required to state your additional grounds or state any other grounds, reasonable grounds on the basis of which you wish to remove. And then just over halfway down 27 on appeal under section 82, Tribunal treats appeals being against any and all appealable decisions.
Although the grounds of appeal have all changed since this.
Yes, they have. Yes, absolutely. This is just for context. 29 making the point that the tribunal may consider evidence relevant to the substance of decision post-dating the decision. So the tribunal, of course, has to consider the situation as of the date of hearing. Paragraph 31, we have the submission by Mr. Fransman, Queen's Counsel, as a broad proposition that in any case where the Secretary didn't concede an appeal in the tribunal, the Secretary of State wasn't at liberty to withdraw the decision unless the conduct of the government was abusive. 32, the court observed that means the Secretary of State, unless she conceded the appeal or the appellant behaved abusively, could never withdraw a decision which was challenged on appeal, even if the Secretary of State wished to reconsider. And the court perhaps not certainly doesn't accept that. And the court then says at 33, line 2, the effect of the appeals legislation is clear. The tribunal has run through the tribunal has jurisdiction on appeal to consider grounds of challenge that weren't raised at the time of the initial application and couldn't have been addressed in the Secretary of State's initial decision. Where the tribunal exercises that jurisdiction, it inevitably becomes the primary decision-making grounds in respect of new grounds of challenge. So that's the effect of the provisions which the Chitvarkins were raising. But at 35, the court says, far from conflicting with applicable legislation, it appears that a decision otherwise lawful on public law grounds to withdraw a challenged decision is entirely consistent with the general scheme of the legislation, because it says under that general scheme it's contemplated that ordinarily the Secretary of State is the primary decision maker rather than the tribunal. Paragraph 37, approving the submission to ICA that this primary role of the Secretary of State also enables certain decisions to be made more effectively and efficiently. 38, the appellate process is itself likely to benefit from a first instance decision by the Secretary of State, thus supporting the idea that a decision can be withdrawn. And then line 5 and 6, promoting the overriding objective of the tribunal in the procedure rules. And then the sentence at the end of 38, favourable decision by the Secretary of Court obviates the need for an appeal altogether. 41, citation from Afghanistan about if there's a concern that the tribunal would be overburdened by an increased role as primary decision maker, the remedy lies in the hand of the Secretary of State. As in case to require the Appellant to state any additional grounds, the Secretary of State should make the necessary administrative and procedural arrangements to enable him to make a decision. The Secretary of State make a decision on decisions on 42. It seems to us that administrative or procedural arrangements can fairly and properly include the withdrawal of the decision under appeal with a view to reconsideration. 43, sorry. So no, 46. The 46. The broad proposition is rejected. The application then narrows to what we believe is the only relevant issue, whether the exercise of the Secretary of public law power to withdraw the decision was taken for a proper purpose. So the reference to the power to withdraw is located in general public law, and then the question is whether it's taken for a proper purpose. Reference to line 4 practically.
I'm conscious of time. I'm conscious that you've obviously seen this afternoon.
I'm going a bit too fast.
I'm going to direct but I've got to be robed to swear someone in at 5 o'clock, which is why I said 4:30 was a hard stop, and
Sorry,
it is.
I was overestimating.
No, don't worry. But it's an important point, because I mean you'll have to address where this sort of implied power comes from, and if there's an implied power one way, it doesn't go the other, and that's too important to rush. So I'll direct short notes on by both sides at 4 p.m. on Monday. Is that all right?
Yes.
Very grateful.
Yeah, and also you owe something to my lady on another point, didn't you?
I do. Can I have the same?
Yes, and to liaise with each other and exchange, because I do not want then to be more exchanges of notes after people have seen points, but I accept sometimes that justice will require that, but it would obviously help if you carry on as you've obviously been doing, cooperating with each other. I'm sorry we can't continue that, but I think the authority is obviously relevant to the point I asked you, and I'd be grateful if both of you can research. If you find any other relevant cases, or you make sure you exchange them between each other before you then put in submission. Good. Well, in which case that only leaves me to thank you and all your teams for the exceptional help we've had. To say that I look forward to, it's probably putting it a bit high, to the notes that we'll get on Monday, and unsurprisingly judgment will be reserved and will be handed down in the usual way. There will be an embargo on the judgment, and as you all know, that can be enforced by contempt of court. Thank you very much indeed for your help.
All rise in favour.